for inclusion, my lord.
Give the inclusion. Yes.
Some urgency, my lord, in the matter I have mentioned, my lord, because there is a stay granted by
It
the,
will come in the next monthly list.
my lord, some urgency, if your lordship kindly, my lord, because, my lord, what happened, the superannuation notice has been stayed after the person got superannuated. And
Date
he,
of birth issue.
yes, my lord, this
It's the
second
date of birth issue.
date of birth issue. Second, I filed this appeal, my lord, with the leave of your lordship, my lord, without the certified copy, my lord. Some bit urgent, my lord, that's why.
Inform them, then you inform us. Take back the slip. Inform them, then you
I will inform again. I will inform because
inform us tomorrow morning. You inform us tomorrow morning after speaking to them that we want to fix it.
I will give a notice to them, my lord. Then.
Please do that. Then you
Now,
mention
if your
after.
lordship takes it up, then I will.
Please do that. Come tomorrow.
Very well, my lord.
Yes.
My lords, with your lordship's leave, may I kindly mention a matter, my lords? There are 3 appeals, my lords. My lords, the Honorable Justice Devanshu Boshak has released it yesterday, and my lords, from the OSD's office, I'm informed it's assigned to my lords. If my lords may kindly be pleased to list the matter. My lords, the official assignment list has not come, but I'm informed from the Chief Justice's office. My lords, it's MAT appeal 1214, 15, and 16. My lords, slightly urgent, my lords.
What is the big grave urgency today?
My lords, the grave urgency, I'll indicate, my lords. My lords, this is concerning the Birla Lodha matter, my lords. It's stemming from the Birla Lodha. My lords, the difficulty is that there is one clarification application which is pending before Justice Amrita Sinha. My lords, that clarification application will decide the signatories of the bank account. It's either my client or the other side's client. My lords, that is listed today. My lords, if that is decided today,
What
then
is listed today?
my lords, that clarification application and my appeal will get infructuous. My lords, I am coming up in appeal against an order by which my intervention and my recall application was rejected, my lords.
Intervention in which proceeding?
My lords,
Intervention in which proceeding?
my lords,
In a writ proceeding.
In the writ proceeding. Well, the writ
So let
petition-
us find out. We are told that it has been assigned. We'll find out.
well, there is an extreme urgency. Is that this pertains to a bank account that was frozen on the basis of our complaint. The complainants were not made parties. Today, the matter is kept today for the bank to figure out and ascertain the aspect of indemnity, and they'll probably go and open or defreeze the bank account. It's been stuck from 21.
Huh?
This bank has been defrozen, this account,
Your issue is whether you are to be impleaded or not.
That's it.
That is the only thing. In
Only-
which proceeding?
in the writ petition. So the writ petition, company A comes to the writ court and says, my account has been frozen at the behest of.
Mention after recess. Let us see what is the assignment. You mention after recess. Yes, call the list. We are told that it has been assigned. Let us see.
Well,
It does not come. Take the number. Find out.
I'll give the particular.
Take the number.
Yes, but I'll seek for one liberty before your lordship. In the unlikely event that the matter is taken up before the single judge, before that, may I just indicate that this is how we are troubling your lordship, and to
This is
this is how we are troubling your lordship today.
who can stop you?
Very-
And why do you need our liberty? We don't even know whether the matter is assigned to us.
For the record.
We are not recording any of
No,
liberty.
of course not. I'm just indicating. not
That
so
is
your
a
lordship don't
pointless
feel that I'm-
submission. That is a pointless submission before us. Whatever you have to say there, you have to say there with responsibility.
Very.
Yes.
Hello, one. I'm for the appeal in lordship. This matter came at my instance, lordship. My senior is there. He's for the state. There are 2 appeals. There is an interim order which will be going to expire tomorrow. Lordship, I mentioned for extension of the interim order that was passed on 7th August 2024.
There is an interim order.
Lordship. That is
Which
expiring
date?
tomorrow. Lordship, last order is. This is the last order. I mean, voted. Voted.
So you are not ready yet.
Yes, I am ready.
Then why we can take it up? We can consider.
Let it be fixed on next week, my lord.
Because I'm led by Mr. Shanna lordship.
It's a case, my lord, I'm submitting. It's a case of a candidate, transgender candidate appeared in the selection test for appointment to the post of primary school teacher, my lord. Though her name has been empaneled in OBC Group B category, but the time Liner single judge
has directed to arrange for 1% reservation for the transgender. There is no scope in the statute for 1% reservation. That is the against which we have come to that. For my knowledge,
Next week when? Tell us.
next week কবে করবি?
Any day. Except next week কথা হচ্ছে just
দেখে নিচ্ছি।
Next week it may not be possible. We have fixed too many matters. Best it will come after next week.
then the week starts on 17th. No.
18th?
তোমাদের instruction
We'll have it on 18th.
18th.
And the entry model is still which date?
Still continuing this.
Okay.
Oh my God, I'm sorry, Malis.
Going to expand tomorrow.
We are informed that the entry model both.
But I'm for the West Bengal.
In one and
I'm
two
the-
both. One and two both.
No, in the second appeal, I'm the appellant, and the other appeal,
So
I'm.
you are appearing in both.
Number 3.
I'm for the response.
Yes.
There's one application which has been filed for addition of parties.
For addition.
Addition of parties, not by us, by a group of respondents and group of workers. And claim through the judgment and order. That should so I affidavits are complete, my lord. I do not know, my lord.
You have to file the opposition.
Yeah, it's on record.
Lord, based on the trial court records, Lord, kindly hear out the appeal. There is
No, what is this application that we are wondering? What-
application, I believe, Lord, some of the employees, they have filed an application for being added as a party.
No, the order under appeal has directed, what has, we don't remember, please just give us 2 minutes. What is
Lord,
the?
the order under appeal directs, Lord, the appellant to pay the liberalized pension to these retirees. That is.
So
that
now
is-
other persons are claiming the benefit under the order. And they are seeking implement in this.
They are seeking implement, Lord, perhaps asking for the same relief.
Yes.
Now, my lord, the order in appeal is very specific to the extent that whoever before the trial court, the benefit only be extended to them and nobody else. My lord. Now,
You are representing those applicants also,
The writ petition.
not the applicant.
not the applicant.
Representing the applicant.
Now, today, my lord, all these
That application you are opposing, you have filed your opposition.
yes, opposition.
Filed.
Yes.
40 minutes, we can proceed.
That application or the
Everything.
fair enough. my lord.
Yes. Yes, your application, what do you have to say? Can for.
Volume 5, paper book. is at page 635.
Yes.
Well, we all are the erstwhile employees under the state of West Bengal.
You have sought a review of the red court order.
No, my.
Then come to paragraph 49.
In my application.
Come to paragraph 49.
My lord.
Your application page 60, sir.
No, my lord, 635.
Huh?
635. My
You
lord,
are
paper
arguing can 4.
can 4.
Your application page 60.
635. Well, volume 5.
Internal page 34 of the impugned order. Internal page 34 of the impugned order, paragraph 49.
My lord, we were not the party to the impugned order, my lord.
Please come to paragraph 49. Need we persuade you by saying it 10 times?
Yes, my lord.
Yes, read it. This is the order under appeal.
This is the order under appeal.
Now tell us. You are not a member of petition number 1?
No.
Then how you can get the benefit of this order in an appeal?
We are not the member of the petitioner number 1. That is the অবসরপ্রাপ্ত ভারতীয় খাদ্য নিগম কর্মচারী সমিতি.
Please see, you have just read paragraph 49. We hope you have read it because we have already asked you at least 4 times. After reading it, please make your submission. What is the scope?
Yes, ma'am.
Members of
My lord, I can't.
take down. We have heard the learned advocate for the applicant.
Very short time that is involved. Let with regard to category of millet entities. Now, millet, there are when HCI millet recruited millet, there were three categories. Firstly is the direct recruitment of FCI. FCI makes an advertisement, millet, they come and millet apply examination. The process within the millet organization. The second is millet persons who are employed in the central government department absorbed deeply. This category who recruited organizational structure similar. The third category. The third category is state governments, income-based, because they are working outside CI. Of 66 that we are next. Now, interestingly, there is a section CI. It is the amended provision. The virtue of the amended provision, which act, it's a Food Corporation of India Act.
Yes.
Virtue of this. From the central government.
So they will not be a loser in the process.
Yes.
That is your submission.
Yes. What? समझे कौन पाता है the argument your lordship to the ones. I'll just take a minute of your lordship.
Why the occasion arose in 1966? They were surplus staff, or why they were deputed?
But after Food Corporation of India was constituted, Lord, they needed staff. So recruitment was made, some from the state government, some from the central government. That's how the recruitment started. They started functioning because before the Food Corporation Act came into force and the institution came into being, Lord, it was the government of India which was controlling the distribution of
These godowns and all these things.
Lordship, if Lordship kindly take the stay application, this application, Milad,
It is in the paper book,
also in volume 1, I believe.
volume 1.
I can refer to the stay application once, Milad.
All right, you can.
Yeah. Signature in the stay application, Milad. This is the agreement.
Agreement.
Yes, Milad, this is a letter. Page number 64 of volume 1, which is corresponding to page 4 state petition, Milad.
Yeah, volume 1.
Page
61.
Yeah, 64. 64, which is corresponding to 4, Milad. I'm sorry, I will go back and forth with the state petition also, Milad. So, Lordship,
As long as we can find it.
I will try and make your Lordship's task a bit easier by corresponding to this, Milad. Yes. This is the document, Milad, I'm referring to. Milad. It's a form of a letter, Milad, with the terms and conditions, and what will kindly see. I am directed by the government of the state of West Bengal to state that the government of West Bengal, the state government, should be entrusted with undertaking on which information of the state government. This was the amendment in 66 terms and conditions with your Lordship. This other shows so Milad, as we stand, Milad, this agreement is still goes. So this is in operation. So everybody coming in have must state government be governed by this agreement and no other thing, no other agreement, no other statute, Milad.
On this date, the statute had come into existence.
Yeah, statute. Yes.
What is the date of coming into force of that statute?
I FCI Act, I will just check, Milad.
Yes, you proceed. You will give the date.
10th December 1964.
Which is 1966.
64. At the top, Lord, your Lordships will find the act.
Oh,
which
you have just given us. Yes, we have not seen that. Very well.
It's 1964 and the agreement is 66. So the statute precedes the agreement, Milad. It would have been the agreement would have been.
Yes.
That's the
That would make a difference. Therefore,
interpretation. My lord.
let's
That would just let. I'm sorry. দেখা বসুন। But will kindly see paragraph 9A and page 69, Lordship kind.
9A, B, and C also.
A, B, and C. Precisely. I'm so sorry.
We are just going through that.
What happens when things get cut on the old documents, when it happens all the time. It's a big difficulty when it face. A portion of it gets deleted from the original when you scan.
Speaking of difficulty, still now, I find it difficult to deal with the way your files are. I used to a much more systematic format. Anyway,
Yeah, Millet. Please, Millet.
yes.
Millet. 9A speaks of Millet to facilitate smooth transfer functions under this agreement by the state government to the corporation. The latter shall take over all the officers and staffs of the estate government actually engaged on these functions at present under the state government, unless for special reasons any such officers and staff the corporation shall have the right to review its staffing it of its experience and absorb such of the officers and staff as were taken by consisting of officers of the corporation and state government. B, such time as the government taken over were absorbed by the corporation. Such officers and staff of corporation shall and the state government. So when they are talking subjecting themselves to the condition specifically regard to the scale of the central government and the scale of the state government. The logical interpretation of it, what I understand. So, in quotations, it's story. I'm thankful to my service conditions. It is also appreciated here for its conditions. Service conditions.
That is while on deputation. So now they have been regularized.
Yes, yes. So still, may I there are circulars and conditions. I can come on the if your lordship gives me some time. Answer the lordship or something. One, Here, so,
Why we raise this query?
yes.
Maybe C is relevant to regularized people.
Yes, I'm on that with your worships. Some of you are service regulation of the state government gives regulars skills and we can jump a step up and ask so that now I can regularize. I'm entitled to the service commissions and the central government. This is the final citation announcements of the Supreme Court. In some cases, Supreme Court has said, well, once you regularize the organization, it is otherwise, if it is otherwise, well, service commissions, there are some cases in the Supreme Court said, since you show those judgments, well, then you come to show, at time seek parity. But now I'm under the umbrella of here in this case, FCI in other organizations, you should remember the side that the Western similar issue came up. Central government organizations, this issue came up with it. Beside that, Millet.
So at the time of the regularization, any further agreement or regulation was
Precisely, Millet. Precisely, Millet. I thought of your bench, Millet. Absolutely correct, Millet. Absolutely. The circular is at page 75, Millet.
19th of March, 1980.
May I, Millet, before Millet jumping into 75, may I read the entire paragraph once, Millet? And they are seeking parity. See this one? They are seeking parity on retirement benefits. Nothing else. The whole claim is based. They say that we are getting a pension after we retire because we were not being with directly. Oh, instructions
claim will have to be founded on a revision of the maybe notional of the salary last pay drawn. Otherwise,
yes.
how can they?
Precisely. So if I'm, say for example, if I'm drawing 2,000 for example, and he is on reputation the state government. Calculated on the constitutional salary of man, it will be calculated on the constitutional salary of Mr. Chakraborty. Chakraborty comes up and says, no, now sure. That's okay. That's the fine distinction, Millet. May I?
That amounted
an example of the IPSs and WBCS officers who becomes the IPS officers recruited service commission where the skills are.
There is a statute, IAS, IPS pay rules govern.
Absolutely well. Here also, the statutes precisely on the FCI Act precisely crystallizes get what and the agreement will it. It is the short point, Millet. Read out, Millet, the 9B once more, Millet, where I paused for a moment, Millet. The other terms and provisions, fifth line from the top, Millet. Other terms and conditions of the deputation will be settled. Mutual consultation between the corporation and the state government, which in any case shall not be favorable than what is admissible under the West Bengal rules. Coming back to West Bengal rules, the corporation shall bear leave salary and pensionary contribution for the staff that would be on deputation. The other terms and conditions of their deputation will be settled by mutual consultation between the corporation and the state government. In any case, shall not be less favorable than what is admissible under the West Bengal rules. The corporation shall give leave salary and pensionary contribution for the staff that would be on deputation to it. Now, see, in respect of officers, staff shall observe service shall make regulations under the food corporation such manner as to conditions of service that government such officers and staff print under the government.
Probably conform,
Yes,
not confirm.
should be confirmed.
FORM.
FOR, confirm. So now under the government, under of this under the government, its interpretation is the applicable service permissions as decided by if we are interpreting this contract, if I go to the very basic of interpretation mode, go to mode, where it is mentioning it's to be of the fixation of the central government. So that we get vision central government will be done. If I take the interpretation of that contract is nothing on Millard, and if I put this question to myself, Millard, whether the agreement otherwise also speaks of something else, which is substantial, which is not spelled through it's got something else and not its implements. Perhaps Millard, interpretation respect to submission will be slightly far-fetched.
So this government has been interpreted by the single judge to mean the central government.
Yes.
According to you, it is the means the state government.
Yes.
Because
Unless
it is
Millard,
to be read justem generis with the other two, wherein it says
I'm-
no lesser benefits.
I'm deep.
That's your case.
This is the only point, Millard. The whole fight is, Millard, whether I come within that, or rather, Mr. Kaur's clients come within the category. If I take the or the other interpretation of this expression under the government, whether it is the under the government, under the central government,
We have not gone beyond this, but as on a plain reading of C, what we find is to give effect to this, there should be some regulations made by the corporation.
yes.
So ultimately, whatever is incorporated in the regulation, if made, that will govern, or we will have to look into the agreement.
Precisely.
Regulation which has been, if at all, we don't know, has a regulation be?
There's a circular. I will show that circular. It is an
He says the corporation shall make regulations.
Yes, that regulation is the circular that I was mentioning at page 75. And page
So anything else from this agreement, or we can go to 75?
I think I have Millard perhaps made my point clear so far as this aspect is concerned. How to interpret this expression under the
government.
Millard. Nothing more, nothing less. Millard, I will not trouble your lordship with other aspects of this because we are in sync with Mr. Kaur that we are not looking beyond anything that because this is the short point that is involved. Millard.
I'm not looking at the agreement at all.
That is.
We are not in. I look at the future.
But I will, if I may, like take this slightest liberty from Shubhamid, I will place this from this circular movement. And then, Millard, I will just refer to Millard, the improvement order, and then Millard, on the next day, if your lordship gives me one more, Millard, I will just prepare a short note, Millard, a short written notes,
I
Millard.
want to give a short note. I am very averse to short notes. You argue and then in short notes we get many new things. It becomes difficult. You should come with a short notes that these are the points I am going to argue and then argue. Otherwise,
That's precisely what I'm going to do. I will close this, allow me to just give the compilation of the judgments. Right? It's much liberty I'm seeking, Millard. May I please this, Millard?
we will take note of your submissions in court today. If you miss anything, you can point it out.
Yes. 75 million. The question, should we finally see, it's dated 1994. Corporation of India,
So this is the, whatever it is, regulation circular, whatever it is, page 75. This is
in terms of 9C.
9C.
Yes.
Yes.
The question regarding absorption was when state government is deputationist is engaging in management. Because again, listed for absorption CI require the should plan I should form actually as an extra one. The absorption of the functions. Government employs the absorption in the service of the population treated as recruit and will be subject to the terms and conditions prescribed under FCI Staff Regulation 17. There we count seniority in the post grade 1, which they absorb from the date of absorption in the corporation. Details indicating the post and scale of pay issued by the state government deputationist as also correspond on FCI and the scale of pay attached to the post is indicated in Annexure 2. The employees who opt for absorption of the corporation will be initially appointed to the corresponding post indicated therein. West Bengal state government employees portion of FCA for a period of at least 4 years as of for adoption in service of the corporation. So these are the 4 kind of guidelines that were set. Annexure 1 was given with regard to what in which they want to apply, and Annexure 2 is what would be their grade. Now 5 and 6 are very important. For the above service record, prior to the date of absorption in FCI, the employees concerned with the pension, income, retirement, gratuity, and other benefits, if any, as applicable to development. So 9C, if we go back to 9C, which the FCI to formulate certain form was the expression. This is it, Millard. The FCI would of absorption in the service of the corporation. 6 million invested for absorption in the service of the corporation of India action is quite far. Again, this is countersign, Millard. So, Millard, the question, if red side, the agreement of 66, clearly 9C, Millard, it would be, Millard, abundantly clear, Millard, that of 9C is born is the circular that has been enacted in 1984. I'm sorry.
Seeking for my lord's kind leave.
Yes.
But may I also, Millard, since Mr. Also, Millard, we come back on Wednesday only on the competition. I do not have much to on to that a compilation on to the missing deadlines, and then Mr. Kaur can start over, Millard. Any day next week except 4th, Millard.
So that your submission is over.
On the compilation of the judgments and Millard, some additional points which I have not addressed.
Let senior
Millard and Millard.
Let senior advocate.
Well, criticism is not my thing. Well, I may have a different view, but I cannot really criticize the judgment. I'm not grateful with it.
কবে দিল ডেট কবে দিল
Write assailed instead of criticized. Write assailed instead of criticized.
But I am for the petitioner.
Matter, on behalf of learned AGP, I am praying not this.
For that matter, where the records were to be,
Records were produced.
let her be here, please.
But this matter, I am appealing for the respondent number 6, my lord.
Yes, sir. Yes.
My lord, may I request one thing? My lord, my learned senior friend, my lord, handed over this compilation. My lord, I shall place certain documents from this compilation. It is not paginated, my lord. If your lordship kindly give
Please, yes, please do it.
within 5 minutes, my lord.
Yes, yes, yes. Give it to. We have got a copy of that.
Yes, that was produced. Do the copy.
Give the copy. Have it synchronized. Have the
Yes, yes.
paging synchronized with you and the state and everything. That will facilitate. The learned
item number 5
My lord, item number 5, my lord, yesterday my lord, item number 31 is similar matter where your lordships were directed to file a report, my lord. Yesterday I make this list item number 31. There is a direction to file a
let us see this matter first. What is this? This is WPA. Where is the tribunal's order?
Yes.
এই করেছিল।
করে দিয়েছি হ্যাঁ বুঝলো তো শুনে ফাইলটা
Yes.
And that's on 18th September 2023, my lord, recorded the order. The citing suggests that the Director of Health Service places a file with the Finance Department for upgradation of pay scale. Finally, see the order dated 18th September 2023, my lord.
18 September.
18th September 2023, passed in this matter.
Yes.
Yes, thereafter, your lordships also direct the state respondents to file a report in this matter whether the file.
No, where is this 15 September 23 document?
That was not supplied to us also, my lord. It was recorded that.
How that is relevant? We have to see the tribunal's order. Tell us what is wrong with the tribunal's order.
In item number 31, my lord, your lordships was also directed to file a report whether the file has been sent to the Finance Department for.
It is the same issue.
Same issue, my lord. Same issue. These two matters are same. Item number 31.
They are also storekeeper in health department.
Same.
31 का file है.
Article list.
Yeah. 31. Report for what? What report will they
My lord, the order of the tribunal, my lord, page paragraph.
You are a storekeeper.
Yes.
Earlier you were at par in terms of your emoluments and conditions with other persons, including the pharmacist and all this. So historically there was a parity, which was later on bifurcated, giving regard to their professional degree, they were given a higher scale. That is over. Now you are saying that storekeeper in other departments, we are claiming parity with them because we are discharging the same work. The tribunal said you have not produced anything to show that there is a parity in terms of the educational qualification for recruitment, etc. So let us see.
Well, kindly see the paragraph 8 of the judgment of the tribunal, my lord.
Yes.
We are of the opinion that regard upgradation of scale of pay of scorecard should be linked for structuring the grade. The government should therefore seriously consider the suggestion of the pay commission in regard to the post of storekeeper under the health and family welfare departments. That's why, my lord, the court directed to file a report in this regard. And thereafter, tribunal said there is no merit in this petition, my lord.
Paragraph 8.
Paragraph 8, last portion. The opinion. We are of the opinion.
So there is no decision in terms of paragraph 9,
Yes, my lord.
not
There is
8, paragraph 9.
Yes, there
The
is
direction
decision,
is in paragraph 9.
no decision as yet. That's why your lordships also directed to file a report whether there is any decision or not, and to file a report.
That is not an issue in the writ petition. For that implementation of that direction, whether we are to exercise a writ jurisdiction or you have to invoke the contempt jurisdiction of the tribe. Both writ petitions arise out of the same order,
Same order.
or orders are different.
Same order. 2 writ petitions was filed, and
2.
yes,
Why?
and they are separate.
By number 1284, 1284 and 1285. Also, both were considered together
Yes,
and disposed of by common order.
common order.
Where is the AGP? Which AGP is appearing in this?
Chadri Alum is appearing in for this matter. In this matter,
We are informed that she is unwell. We have been adjourning the matters in this week.
make it not today, then I shall serve a notice.
Ask her to be here. They have not served anything yet.
I have gathered the information. They have received the instruction,
Oh, it has. They have got it.
but that was not served upon us.
Tomorrow it will come with a note, not today. Hopefully, the AGP will be here on Monday.
Plus, this 2 matter will be
Both matters, yes. You are appearing in both. Yes, she is here. Ask her if she has got any instruction.
পেয়েছি। আচ্ছা, বলুন সেটা তো কথা। এটা 5 হচ্ছে, যশাই বিকাশ করছে, ওটা পেয়েছি।
31 not come, my lord. Kindly fix it next week, my lord. Mrs. Salam will come next week. So
You have got any instructions
I have a talk.
on grounds of illness of the land? No, hearing will be taken. We can tag both the files.
Yes.
Parties are in agreement. The parties are in agreement that since
Big factor.
6.
5 August.
Item number 6.
But I am for the petitioner, my lord. Last occasion, my lord, direction was given for filing of a reply, my lord. Sorry, opposition, my lord. In opposition. In the meantime, my lord, there is a change, my lord.
what opposition, sir? What is the order under challenge? Let's
My
see.
lord, my pension and other retirement benefit, my lord, my lord, paid to me, my lord, but delayed payment. Interest I have, my lord, already, my lord, paid before the tribunal. the tribunal has not been taken into consideration. That is the main plan. My page 19 is my prayer, my lord, before the learned tribunal.
Who is appearing for the state?
My lord, new incumbent already, my lord, taken into charge, but I have to sub copy, my lord. Otherwise, my lord, how they will appear?
Yes, you are.
My lord,
No. Who will appear?
if your lordship directed, my lord, I can give her a copy, my lord.
Mr. Salam is not appearing. Item number 7.
This order has not been challenged by the state.
No, no, no.
From the order of
In the meantime, grateful to your lord.
Item number 7.
Seven, my lord, Mr. Salam is appearing. Seven, in number
As played by the learned State Council is after 1 week.
One week.
My lord,
Yes.
Item number 8.
Lord, 8, Mr. Salam is appearing on behalf of the state appellant, my lord.
As played list after 1 week.
Oh, yeah. Item number 9.
I am appearing for the petitioner. I'm seeking for a week's accommodation.
Why, sir?
Huh?
Why, sir?
My lord, I have been instructed to.
So you are not an advocate on record?
No, my lord.
Yesterday we had adjourned it for the day.
My lord, I don't have any details of that particular case. I have just received the instructions and
Not today.
get
Item number 10.
Have a look at the last order, my lord, 11th July 2024, my lord.
What is the date of that order?
My lord, 11 It's 11th July 2024.
There is the date. Here is the date. I have been telling you again and again why you don't close the folder after the case is over. The way to keep the records. Certain. Yes, they are not filed.
I am expecting if today I will get the affidavit in opposition, but not yet. Even after 1 year, I have not received, my lord. So problem is, my lord, even it is an urgent matter, my lord. Presently, my lord, I require the 15 days time, my lord, or at least 2 weeks time, my lord, because I have to examine thoroughly, my lord.
No, see, forget about any opposition. You are seeking VRS. You are a medical officer under the West Bengal Medical Education Service.
My lord.
75 triple A. In view of 75 triple A, can your application for VRS be considered?
That is the main issue.
That is the only issue.
No, my lord. That is the main issue. But my application was under DCRG rule, my lord, not under rule 75.
All right. So let us see which provision.
Same, my lord. Both are not same. I will argue, my lord. And most important thing, my lord.
Under which provision? Which provision of DCRB?
My lord, rejected by the
under which
my appointing authority.
Under which provision by the which provision of the DCRB you can overcome 75 triple A? Tell us. How you can overcome the bar under 75 triple A? Based on which provision under the DCRB? Show us.
That I will make submission, my lord, after study, my lord.
When? Yesterday also it was adjourned.
Because, my lord, I didn't.
Every day it can't be adjourned.
Because both the rules are independent statutory rules.
So show us which rule you are relying upon.
Because now I am not with my brief, my lord. That's why.
Why, sir? Yesterday also it was taken up.
My lord, I am expecting the opposition, my lord.
No, we don't want opposition. You tell us.
Right, I am grateful for that.
We don't want any opposition.
I am grateful.
If you are making out a case, then we'll ask them to.
I will come. So please kindly allow me.
Tomorrow, come tomorrow.
My lord, 2 weeks time.
No question of 2 weeks.
It will be difficult to trace out.
No question of 2 weeks time, sir. List on Monday. Give the date of Monday. To go through it. Unnecessary, these matters are pending for no reason whatsoever. On Monday at the top of the list. Yes.
My lord, let the fix up.
Sorry.
My lord,
Monday.
My lord, just consider my age, my lord.
That is no ground, sir. Please don't bring your personal issues into the court. Don't do it. We don't appreciate. Yes.
Item 11.
Item is the same prayer, my lord. Item 11.
As
Didi?
opposition advocate list in the next one.
Fire. Item 12.
Hello, time for the state led by London Chief Tribunal.
Lordship, this is that matter. The higher pay scale of the ITI teachers, Lordship.
Higher pay scale of?
ITI teachers. Lordship, Justice D.K. Basu's order on the earlier occasion I have relied upon. Lordship kindly comes to page number 38 of the supplementary affidavit, which is the OA.
Sorry, which page?
Page number, it starts from page 37 and the ordering portion is page 38 of supplementary affidavit. Lordship is there. Lordship, the middle paragraph. না এই আমার কাছে এক্সট্রা কপি তাই
Yes.
Yes.
Lordship, I have gone through the order. Lordship, may I read the order once?
Which order?
The Justice D.K. Basu's order, by which order, Lordship, the staffs of the ITI Association have been
High Court order or Supreme?
the High Court order, Lordship.
Yes.
It was page 37. It starts from 37, and the ordering portion is the middle portion of page 38, Lordship. May I read, Lordship? I think and hold that all
The reading it to establish that you can claim parity with, you are on which post?
Now I am teacher, Lordship, as per the High Court's direction, and
You are teacher on which post?
instructor,
Instructor. You are having teaching status.
Lordship.
So instructor, you are just instructor in ITI claiming parity with instructor in the degree colleges.
Lordship, may I?
In terms of the pay and emoluments.
Lordship.
Regarding the pay and emoluments.
May,
So for that you are relying on the High Court judgment.
no, Lordship, may I submit?
Yes.
Lordship, the order, Lordship, may I read once? The ordering.
For what we are asking you? What do you want to show?
After this order, they have issued the government order, by which we have offered the post of teachers, and our retirement age has been extended from 58 to 60.
You have given the status of teachers of ITI.
Lordship.
Yes.
Now, Lordship, before the post that has been offered teacher, the pay scale that was same, Lordship. After and before, the pay scale is same.
Yes.
No change of pay scale.
Correct.
Before we were not the teachers, non-teaching staffs. Now we have been.
You have been declared to be a teaching staff, still your scale remains the same.
Same, Lordship. No change of scale.
So where the High Court said to give the higher scale, just read what it says.
Not the higher scale. I am relying on existing pay scale of teachers that has recorded in the order, Lordship.
No, not of teachers. Where does it say existing pay scale of teacher? Read.
I think and hold that all the writ petitioners are entitled to have a status of teacher and existing scale of pay with immediate effect.
Yes. Which paragraph? Which page?
Lordship, page 38 of the supplementary affidavit.
That is not the order. The order is at page 40. Come to page 40.
Page 40, Lordship.
Yes.
40. Lordship, it is continuing by page 38. There is also observation, Lordship. Kindly comes to page 38 once, Lordship. The middle paragraph.
You may read.
Lordship, the middle, it starts from in different actions, and in the middle, Lordship, I think and hold that all the writ petitioners are entitled to have a status of teacher and the existing scale of pay with immediate effect. If any of the petitioners have since been superannuated, he shall be reinstated in the service with back wages so that he can get all the benefits in the status of teacher. Now, Lordship, after the change of status, the scale of pay, what I was enjoying, after the change, the same pay scale I am enjoying, Lordship. Now, Lordship, kindly comes to the page number. Kindly comes to the judgment, Supreme Court's judgment, Lordship, once. Lordship, that is the paragraph number 9, page 46 of the supplementary affidavit, paragraph number 19 of the supplementary affidavit, Lordship.
So page 38 and which paragraph?
Page 38, the middle paragraph.
This is the High Court judgment.
Yes.
And in the Supreme Court judgment?
Supreme Court judgment, Lordship, page 46, paragraph number 19. Anil Ratan Sarkar's case, Lordship.
The department is right.
Paragraph number 19. Lordship, I was relying on paragraph number 19 of the Supreme Court's order, Lordship, page 46 of the supplementary affidavit. Lordship, Lordship, but the observations of the Honorable Supreme Court that non-teaching staff salary is 13, Group B employee salary 1390 to 2970, but teaching post salary starts from 2000 2200, Lordship. Now, Lordship, our status has been changed to teachers, Lordship. Before the change of status, we were enjoying the same salary. After the change of status, we are enjoying the same salary. Paragraph number 5.
March 69, they were all getting the same.
Lordship.
March 69, for the first time, they were deprived.
Lordship.
That condition we have never got.
Lordship, now, Lordship. Lordship. Lordship, in the Principal Secretary's order, they have. Lordship, I am coming. That starts from page 101. They have never stated anything about the change of Vipati Tribunal. They have never stated anything about the pay scale, Lordship. Before the status was changed, we were enjoying the same salary, same pay scale, representation before the Principal Secretary. Lordship, I'm coming. It starts from page 59. না এইটার পরে তো হাইকোর্টে গেছে আমি না না এই দেখুন
The teaching.
Lordship, got the government order? Not sure. গভর্নমেন্ট অর্ডারটা যেটা আমাদেরকে টিচিং স্ট্যাটাস দেওয়া হলো এইটা লর্ডশিপ পেজ 33 supplementary affidavit page 33 lordship supplementary the OA is annexed in the supplementary affidavit.
পারমিশন আছে কম করেছে তবু টাকা পায় Page 37 17 December ডেটটা কত 17 ডিসেম্বর 97 Lordship, it is 17 ওকে ঠিক আছে 3rd ডিসেম্বর লাগছে 17th ডিসেম্বর 1997 এই যে সার্টিফাইড কপি ও সার্টিফাইড কপি sorry third December no there is another judgment passed by Justice Altamas Kabir Lordship, it is not annexed in the way Justice Altamas, but it has been cited in the judgment passed by Justice D.K. Basu. Lordship, page 38, the last paragraph, Lordship, it has been quoted, cited.
Part of that judgment, you are not reading this judgment. Judgment is at page 40. Because even at page 30, perhaps the extract of another judgment. How that judgment was. How we can know was that judgment.
Lordship, then Lordship, I have to come back with the copy.
Then we asked you last day also the same thing. If this is all you have to submit, then we can conclude.
আপনার কপিতে দেখুন, আপনার কপিতে।
Yes.
Lordship, may I come back with the copy of the judgment, Lordship?
What is the staffing pattern in the ITI?
Lordship,
Who is above you in the teaching cadre in the ITI?
instructor, thereafter supervisor, thereafter foreman.
Instructor, supervisor, and
Foreman.
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 There is no such thing as a lecturer or teacher, nothing of that kind.
No.
So, you are to be placed in which scale?
Lordship,
You are to be placed in which scale according to you?
pay scale, pay scale.
Yes, sir. That is all. That is your claim.
2200 to 4000.
It is being given to whom? It is being given to the supervisor.
Instructor.
Above you, there is supervisor, and above them is the foreman. This 2200 is being paid to which of these persons?
So instructor will get the pay scale of 2200 to 4000.
No, he will not. That is what you are claiming. He will get a different pay scale. You are claiming 2200. You say, I have got a teacher status. Give me the 2200 scale. So 2200 scale is being given to which teacher in ITI?
As per my instruction,
the promotional post of instructor, Lordship.
No, sir, that is the wrong instruction. That you are not getting, that is your claim in the present writ petition.
Lordship. Yes, that is my, no, I am not getting that.
You are not getting it. Who is getting it in RTI? That we are asking you.
I am getting pay scale of 1390.
How many times you will say that? That I am getting 13, I want 22. We are asking you that there is a change in your status. From not teaching, you have become teaching. So you want 2200, which is being paid to teacher. Which teacher is getting 2200 in ITI?
No one is getting.
No one is getting exactly. So you are not claiming the skill of teacher in ITI. You are claiming degree colleges. Now, can you do that? That is the issue.
I am claiming the pay scale of the instructor, Lordship.
No, you are not. You are instructor.
Lordship.
You are not claiming any pay scale of, you are claiming pay scale of instructor in degree college. You are omitting to say that, but you are claiming the pay scale of instructor being paid to instructor in degree college under the universities. So can you claim a parity with those working in the degree college? That is the issue. So what is there in support of your submission? Let us see. We have understood that the High Court held that because you are imparting teaching, you are giving instruction to the students, therefore you should be considered as teaching, not non-teaching. Now, by virtue of becoming teaching staff, you say I should get a scale given to teachers in degree colleges. How can you claim parity with them?
Another thing, what I was submitting before the change of status, the same scale of pay I was enjoying. After the change of status, there is no change.
Therefore, you are saying the change should be now, when you rely on the Supreme Court judgment, then you say I should be given the judgment, the scale for teaching staff. But in your organization, there is no scale. So therefore, now you are relying upon the scale in the degree college. Issue will remain the same, whether you can claim parity with those serving as instructor in a degree college. So what is your case? How you can claim a parity with those serving in degree colleges where the entire thing is different?
Polytechnic.
The Supreme Court judgment you are relying upon, there the instructors were earlier teaching staff. In 69, they were treated as non-teaching, whereas others were treated as teaching. The Supreme Court said no. They have historically been treated as teaching staff. They are imparting teaching. You treat them as teaching staff, then they became at par with teachers in their organization. You are not claiming parity with anyone in your organization. You are saying somebody working in degree college. How can you sustain such a plea? That is what we are asking you. Neither the work profile will be one and the same. In the degree colleges, the education being imparted is totally different. Here it is more of a vocational training. There is a academic. So how can you claim parity? That is what we are asking you.
Lordship, in that case, may I come back, Lordship?
Every day we ask you a question, you will ask for
one last opportunity. I will.
As prayed. We after some arguments and that is the issue. That is
Your lordship has rightly pointed out the qualification itself is
no, that is the issue arising for concern.
Item number
Whether we are right or wrong. We are claiming the status of physical instructor of colleges.
No, whatever it is, they are seeking parity with degree college.
Colleges. And they are completely different, my lord, here.
Let's see.
Different, my lord.
Lordship, we are for the applicant. The learned advocate on record is currently engaged in circuit bench. That's why for today I'm seeking an accommodation.
Not today.
Not this week. If your
Still the
lordship
next
schedule.
Yes.
Item 14.
14, if my lord recollects, this is the copywriter's matter. But pursuant to my lord's last order, we have mentioned before code number 17, my lord directed that since the matter is fixed on 30th, mentioned on 30th. Today, the matter is appearing bearing item number 11 before courtroom number 17. Sir, kindly see the last order, my lord. It will be released from his lordship and assigned to my lord's court, so that
No steps have been taken till now.
no steps has been taken, but my lord directed since the matter is fixed today, so mention
As per list after 1 week.
13th August.
Okay. Item number 15.
Yes. You are respondent.
I am respondent.
I'm led by Mr. Subis.
Affidavit of service. In fact, this was taken up first trial.
Don't rely on our memory. Arises out of order passed in contempt.
Yes. No, hi.
At the type of content.
At the time, at the stage of contempt, a recalling preferred after 8 years, recalling taken up by the contempt judge, and one fine morning, the order of the parent order was given to go by. Whereas the erstwhile contempt courts has already taken initiation of the contempt.
Lordship, I am for the state, led by Mr. Debashish Basu, AGP, Lordship. Lordship, prefer not today, Lordship.
This was regular occasions this is going on.
No, Lordship, he is due to his personal difficulty, he is not available today. Only not today, Lordship.
Not.
And, Lordship, can you hear me for 2 minutes?
Yes.
Lordship,
See, we can do it, but it will be of.
But she will find this order cannot stand even for a minute.
So it is a pointless today to go into it. That's what we are saying. Let him be here. It's not today only. Some personal difficulty.
Monday at 2 p.m. would your Lordship's preference?
We don't know whether we have free on 2 p.m. at Monday.
No, kindly. Otherwise,
let us see.
Yes.
Thank you. State is every day asking for time.
That's what I told.
Every day they are asking for either copy, even the copy is served upon the GP, they have not got it. Again, I have to give the second copy.
They have taken time earlier.
Yes, Lordship will find the same.
Lordship, only today. Lordship.
This matter was taken
Each
on
and
board.
every matter we are facing this, my lord.
Due to personal difficulty, Senior Mr. Debashish Basu, AGP, are not available today, Lordship.
On the ground of some personal difficulty, not today only.
All right, Yunus. Hey, Shoma.
That is
Shoma, দুটো
that's a fair.
কবে?
সোমবার দুটোই রাখি। And he says let it be come on a date when it can be fixed at a particular.
Yes, yes, that would be better.
We are checking whether Monday we have 2 p.m. free or not. There's only one matter. Monday 2 p.m.
Monday 2 p.m.
Madam, it will come on Monday at 2 p.m. List on Monday at 2 p.m. as prayed by the learned advocate. State.
Pointless. Therefore, we are.
I follow what's following. It will be a pointless wastage of time. Great.
2 p.m. Item,
Come back.
item 16. Item 16 and 17.
16 and 17, my lord. This is the same prayer, my lord, for the appealing, my lord, necessary. Same prayer, my lord. People service. Mr. Salam is appearing on the state appealing, my lord. Kindly fix it next week, my lord.
Yes. Yes, we know, we have recorded by
Item number 18. नहीं दिए से नहीं नहीं
Something about stuff.
Appearing somewhere, my lord. Somewhere.
I appear for the petitioner.
My lord, Mr.
My lord,
Debashish Saha is appearing.
I am for the appellant. My lord, in terms of your lordship's last order, I have sent in the correct address as amended. My lord,
Number 3.
respondent number 3, private respondent.
3.
Just a minute. 3. This time also it is returned, my lord, with the remarks refused. May I, my lord, file this application? Yes. Your lordship was pleased to, my lord, direct me to make an application for amendment of post title regarding address.
Oh, this is refused.
Yes. Again refused. Or in the the third time, my lord, I sent, my lord.
First time you have sent. Earlier it was wrong.
In the correct.
Earlier it was wrong address. You have not submitted third time.
Yes, my lord.
Yes.
Lordship has members. My lord, In the writ petition, my lord, I have prayed for my lord family pension.
You have amended, just we want to see where you have.
Yes, yes.
It just should be in the. Yes, not today. We'll take it up tomorrow.
Tomorrow.
My lord, kindly take it up next week. Mr. is appearing for the respondent. Who? Mr. Devashya is appearing for the respondent bank. He has gone.
Respondent 3.
Respondent number 2.
Bank.
The bank, my lord. He has gone out of station for some official work. Kindly take it up next week, my
As prayed by learned advocate for the.
Dosa. Dosa.
10th.
Item number 19.
It is our appeal, lordships.
For the respondents.
Will it be my lord's pleasure to fix this up on the 5th, my lords? Because if my lord's pleasure, I beseech your lordships, because I'm in some personal difficulty at 1 o'clock, lordship. What has happened is, if I start today before my lords, maybe, my lord, I'll not be able to complete it. But I beseech, my lords, because of I have prepared myself. I'm not cutting a story figure, but my lords, some pressing problems have.
There is any delay.
Delay has been condoned, lordship.
Any interim order?
No, lordship. Interim order is not there, lordship. We are the appellants, my lord, because the punishment has been reduced, which we have challenged, lordship.
5th, you want on 5th?
Lordship, because my lord has kept another matter with my lords. আপনার সঙ্গে কবে আছে ওইটা 13 তারিখ না তো ওই দিন রাখবো স্যার আপনি
Why do you want to keep 2 of his matters on the same day?
Well, I was just it is in I apologize, Millard, because what happens is, Millard, many a times when I was, Millard, practice one day, Millard, if 2 matters are kept, it was better for me. But then I am busy.
Let him decide. Yes.
Other day.
5th.
5th. As prayed.
I'm grateful.
Item number. I am for the writ petition or appellant.
But 21, I am paying for accommodation for the day, my lord.
Only, not today.
Not today, but tomorrow.
Kindly fixed it on Tuesday.
Tuesday, because Monday is a monthly list day.
All right.
The matter was heard by your lordship. I am to satisfy your lordship on a question of law.
I don't remember but the moment I will see the file, I will remember.
I'll point out your lordship.
The matter where the petitioner was removed from service without an inquiry.
Oh,
yes.
Single bench held that the order is illegal.
Jointly prayed.
Mallet. This matter, Mallet, was heard, your order was fast, but unfortunately, it was recorded in another file, Mallet. Well, this is a case where powers of summary dismissals were invoked, Mallet, and he was a doctor Mallet, in the hospital of the Morocco cantonment.
Other file.
Where is that? It is there also. Today it is there. Yes.
So when that was invoked, Mallet, the
No,
honorable
please, again, please.
The petitioner, the Nagpur Cantonment Board, will invoke power under section 12E, 12E2, which is a power of summary dismissal without conducting the disciplinary proceeding, Mallet. So this is a special power which was invoked, and Mallet, reasons were recorded. The Honorable Court has gone through everything, and then has said, Mallet, that the order, the reasons for not conducting the disciplinary proceeding should be reasonable. But has not held that the reasons which has been recorded in the order are not reasonable, Mallet.
And there is a consequential direction to conduct proceeding.
Yes, Mallet.
You don't want to.
No, Mallet. Because Mallet,
Let's see the provision under which you are claiming to justify your action. Which act, which provision?
Yes. These are called the Cantonment Fund Servants Rules. Wait.
When you had passed the order which was set aside? What is the date of that order?
Original order, my lord. Fifteen 12. No. This month.
16, 29, 7,
29, 7, 16, my lord.
Yes. So for the last 10 years, you are contesting that you don't want to conduct a proceeding against.
I will take your lordship to the order, my lord. Under what circumstance and whether?
No, we are just looking at the timeline. This happens.
Whether, my lord, at all conduct can be.
We are not on merits.
Yes.
We are not on merits. We are just saying that this issue is pending for 10 years. Whether to conduct a proceeding or not.
Lordship, can you see 12E2? The last. 12E. 12E.
Oh, this provision. Which condition you are relying upon?
12E2, my lord. Can you see?
There are so many judgments how to do this. It is a very
Yes.
well settled law.
Yes, my lord. I have. There are three conditions laid down, my lord, which I have fulfilled. It has been reasoned order has been passed. The reasons for not being able to hold the conduct, the full-fledged has been recorded. And by the Honorable Supreme Court has said this is the subjective satisfaction of the disciplinary authority.
Yes, satisfaction, but based on some criteria and some material. Let's see. What is the order? So it is akin to 311.
Yes.
So let us see. Yes. Where is your order?
Well, it is with the memo of appeal, my lord.
No, the order which the trial court has interfered with.
That was with the stay application, my lord.
Because ultimately we have to see whether it is justified or not.
Now, this is a 116-page order, my lord. This is annexed, my lord, with immediately after the affidavit, my lord. Affidavit page 13, my lord. It starts from page 13. My lord, the agenda. This is page 16, my lord. Agenda number.
Resolution number 3.
Resolution 3. Agenda number 3. Well, the first part is relating to a dispute whether he is entitled to leave or not. My lord. During examining this, whether he is entitled to leave, my lord, several discrepancies were found. One after other, they have been all been set out.
All have?
All have been set out in this order. That is why the order is about 116 pages, my lord.
116 pages?
Yes, my lord. This is the whole resolution is of 116 pages. না ওটা আপনি
আমাদের বাবু করতে তুমি
where this aspect is considered, why it is not practicable to hold an inquiry against him.
Well, just data. Well, this is a page 116, my lord. Although, my lord, the reasons, my lord, page 116, my lord. This is 104 of the second paragraph, my lord. The member secretary pointed out that among the limited staff in Cantonment Board office, there is no ability of dedicated and competent resources to handle the case against Vishwas from a vigilance, corruption, security angle, was also deeply concerned about the unholy nexus of Vishwas and office staff, especially senior staff of Cantonment Board, as they have common vested interests. In fact, the member secretary indicated that most of the documentary evidences against Vishwas was found missing from the office record. And when reasons were sought as to what happened, the reply from the senior office staff were casual in stating that those specific particular files related to Vishwas were destroyed by termite white ants under mysterious circumstances. The President Cantonment Board noted that the incumbent CEO is a novice and he is still in probation with experience only 6 months in his first posting as CEO. Hence, he was of the view that incumbent CEO may not be experienced to handle the case against Vishwas, as Vishwas has managed to escape from any action from earlier experienced CEO of Barrackpur over all these years. The President Cantonment was deeply concerned that if immediate action for termination of employment of Vishwas is not taken, then Vishwas will definitely manage to escape again, causing permanent, irrevocable, irredeemable, severe, long-lasting, permanent loss and damage to the local inhabitant population of Barrackpur Cantonment. The board was unanimously of the strong belief that unless an independent, neutral, competent entity is involved, Vishwas will escape from any access, as he is very much capable of tampering or destroying the evidence against him, and does not hesitate to use threat, inducement, promise, fear against possible witnesses to dilute, nullify the whole case against him. After substantial thought, elaborate discussion, due deliberation, careful consideration, the board, as it was the appointing disciplinary authority of Vishwas, since he is holding the supervisory post of assistant surgeon, residential cantonment, Jagadish Bose General Hospital, Sadar Bajar, Barakpur, under the management of Cantonment Board, Barakpur, was satisfied that it is not reasonably practicable to hold an inquiry in light of Rule 12E of the Cantonment Fund Rules 1937 and in exercise of power conferred upon it by Rule 11(2). Power of the Cantonment Fund Service Rule, the board imposed the major penalty of dismissal on Vishwas to terminate his service, which shall ordinarily be disqualification on Vishwas for future employment under Cantonment Board Barakpur or any other board. The board observed that justice may be delayed but never denied. Further, for ends of justice, the board of directors to forward the case of Vishwas to all concerned authorities, included but not limited to Vigilance Commission, for further necessary action from their end, so that Vishwas does not escape clutches of law and flee from justice. In light of public interest, PCB directed the CEO to implement a way of system in Cantonment office to keep check on such people, etc. His allegations against him were, in his appointed method, defects were found. He has been repeatedly taken leave. He has been doing private practice. He was called to the meeting. When the meeting was going on and evidences were being shown to him, he left the meeting and that started tampering with the same evidence. Website pages were deleted during the meeting. If your lordship wants, I can go through the judgments also, but your lordship has already passed an order. This is why there is.
We have passed an order.
Yes, your lordship had directed the paper books to be filed, but that was recorded in another.
That day, this matter was not placed, another file was placed, so
Yes,
we
yes.
recalled we didn't sign that order.
Yes, yes. But your lordship's opinion was that paper book should be filed along with all documents, and the contempt matter is pending.
Since we have taken it up, let us consider it.
Very well. The writ petition
In practical, what is the scope? Tulsiram Patel judgment and
Yes,
some other
sir.
judgments are there.
Gives 3 conditions whether I have fulfilled.
So this is a very limited scope.
Very
If
well.
you want, we can proceed today. If you want another day, we can fix it for a hearing whenever you want.
But third, the contempt is pending.
এখনই আসছে
Third, fixed and third.
বুঝলো তোমাকে affidavit দিতে
When Mr. Bhattacharya is appearing here, you think he will do something there?
no problem.
No, if they say they will not.
You tell us when you want it. See, it's only examining whether this reason is justified.
Yes, ma'am.
No. Whether such reasons can be justified.
Order? No, my lord. সেটা জজ বলছে যে আমি কোনো লিগ্যাল পয়েন্টে দেখবো, আমি ওটাতে যাব।
ডকুমেন্ট ঠিক আছে no problem. আমি বলবো
No, Mr. Bhattacharya is saying that the records are not here, writ petition. I said, lordship.
You want us to requisition the records?
Court record is before your lordship.
কোনটা বলছেন?
ওটা হলে ভালো হয়।
হ্যাঁ, সেটাই তো।
See the second proviso to 312, whether it will apply or not. The law is settled by a long series of judgments. Whether mere impracticality can sustain such a decision or something more is required. That is the, so we have to see a very narrow scope. Whatever you want, we can requisition.
Yes.
You want the writ records? So we can proceed on which date?
Read court record. Right, read court record.
7th, my lord, August 7th.
Let the trial court records be summoned. You requisition the trial court records.
Read court record না দিয়ে দিবেন।
When do you want?
6 না 6
7th, Friday. 7th Friday.
Give after 2 weeks. Give after 2 weeks.
After 2 weeks, দেখো।
অনেকগুলো চিফের ঘরে ফিক্সড আছে।
11th, 12th.
Today, one of my chief justice was joking me. We are the first court, Mr. Bhattacharya.
Huh?
Yeah,
When I was pointing out that I have other matters fixed in other court, no, we are the first court. I said, but my commitment was 20 crore?
20.
Returnable on such and such date, send it. They will send the records. Anything else has to be required.
Item 22.
I am appealing for the writ petitioner respondent.
Who's the, so in appeal, who's the appellant?
Well, I am for the Indian Statistical Institute.
What is the issue?
My lord, this is the issue of ceiling limit of gratuity payment. My lord, as per the Gratuity Act, there is a ceiling limit of 10 lakhs. The current provision is 10 lakhs. But as per the SSO of Indian Statistical Institute, when the employee joined the institute, there was no ceiling limit. But after that, the Gratuity Act was passed and then it was adopted. Though there was one provision mentioned in one of the clauses that the better provision will be given. Thereby the ceiling limit goes, which was pointed out by the audit report, and thereafter the council has adopted the newer version, which is as per the law, according to us, that there must be a ceiling limit, since Indian Statistical Institute is not a revenue generating body. If some financial provision, financial extra payment is to be adopted, there must be financial approval from the MOSPI. Means from the MOSPI, Ministry of Statistical and Program Implementation, under which this autonomous institute is working, because the autonomy is about academics and not about. Yes, my lord. The entire finance is coming from MOSPI, from Ministry.
From the ministry or
The ministry. Therefore, for any financial implication, any decision which is having financial implication, there must be approval from the ministry. But my lord, in the initial adoption of the Payment of Gratuity Act, the ceiling limit was not taken into account. This is the case all about.
So you want to introduce that ceiling? Or you have introduced?
Yes.
Or you have introduced, which is the subject matter?
Yes, my lord. And earlier.
Altering the service conditions of the existing employers.
Yes, my lord. It was misapplication of the entire thing.
Whatever it was, it will alter the existing service conditions of the existing employees to their disadvantage.
My lord, it was wrongfully
Now, whether
given
it can be done retrospectively or it will apply prospectively, maybe perhaps that will be the issue.
That is, my lord, one of the issue. Another issue is, my lord, the Payment of Gratuity Act itself, Section 4.
Yes, there is scope.
Recognizes, my lord, the entitlement of an employee to receive higher.
Yes, there is a scope. There is no statutory absolute bar. That
my
R
lord,
is subject to exceptions.
Yes, my lord. That is the dispute all about, because in the initial appointment letter, if we take it as a contract, there was specifically it was mentioned that whatever will be the government rule, it will be applicable. My lord, it was misapplication of government rule. Whatever the SSO was taken, the council decision was taken at that time.
You're taking a stand that we are only correcting an error.
My lord, it was misapplication.
Very well, let us see. The record is complete.
Yes, my lord, only the affidavit in reply which was filed before the learned single judge is not on record.
You filed it.
Yes.
So place it on record.
My lord.
You place it on record. You should have incorporated that in your intra-court appeal.
Affidavit in opposition of ISI is on record, but the affidavit in reply to the opposition is not on record. Opposition is appearing at page
File
88
it.
to
You
90.
file it so that we can proceed.
My lord.
Yeah. Prepare a convenience paper book. Incorporate the reply also.
Stop.
Mr.
Now the assignment has happened. Your Lordship could, the matter is going to appear after recess before the learned single judge today and then after Thursday next. So anytime Monday or Tuesday, if your Lordship could consider. It's just a short point of my, yes, not be mentioning upon notice. Yes, other side is also here.
This is one of the classic cases. They've lost once. Single judge, Supreme Court. Whenever they do it, they do it. But the Supreme Court's order is by 8th August, the single judge matters have to be disposed of. So that's in my lordship.
That's right.
Why not Saturday? We should have Saturday.
No, Saturday to go. No, Monday if we could come back. No. I understand which way this is going, but Saturday will be a little difficult. Monday if you could come back. No. Yes, intervention in a and recalling of the order, disposing of the writ petition, because the complainant was not made a party. Just the issue is really short. It'll
Implement.
That's right. Then after recalling, that's right. It's just that. Tuesday, Miller, if you could come back. Please, please. क्या आज का नहीं very grateful.
Original side matter item number 1 and 2.
Item number 1, my lord, I am appearing for the appellant.
Your Lordship, may I be permitted to mention, this was the matter fixed at 2 o'clock, item number 66, Your Lordship, involving terrace flat 93. Yes, I had Your Lordship mentioned on a previous occasion, Your Lordship. The seniors are unfortunately not. Tomorrow, Your Lordship, the date has already been given, so all of us will appear tomorrow. But today, the 31st date there, she will be.
You have circulated
Oh.
They can do Saturday. They are on reply. No advocate. They are on reply.
We would love to see them on a Saturday. I obviously am.
Lordship, we have completed our submission, Mr. Mukherjee. Mr. Mitra was on legs, so they are supposed to reply. So they are taking an adjournment, so they can do that.
We have one matter fixed at 2 p.m. There is a resolution.
Tomorrow.
Then, Your Lordship, next week, if we can.
10:30, Your Lordship. Lordship, we do not want to next week any day. Only thing is that because I believe apart from Mr. Mitra, there is Mr. Majumdar, everybody is there. I mean, the full team is there.
Monday after.
Achha.
The problem is we are fixing matters at 2 p.m. every day.
Yes, Your Lordship, I understand the parties are sometimes can be uncooperative.
Monday we'll have it.
Monday
Week.
10th.
10th.
Monday 10th.
But my only request
after 14th, 10 to 14th actually.
Yeah.
This is
10 to 14th.
For whom?
You are for a different party.
He is the advocate on record for the respondent.
10th and then do it. No?
After 14th, then see what date we have. Take your time.
When is it?
19th.
Grateful, Your Lordship.
Only one request, no further adjournments. I mean,
We never pass such an order. Never.
Only because the mentioning notice
cannot continue our discussion for that day under any circumstance.
I understand, Your Lordship, but the mentioning
Nobody knows what will happen.
mentioning notice comes at late at night. Your Lordship, kindly understand. The petitioner is 91.
Your Lordship.
Having that.
7 hours of argument.
I am a decree holder, not enjoying the decree. This is happening. That's the reason I said.
We are not on merits today.
I understand.
All right, it is there. We have fixed
That
it.
is my consideration request to you.
But Your Lordship, the saga of adjournments, Your Lordship, is, I think, the appellants, Your Lordship,
That
has
does not
become.
give you a right to respond in the same. So you just proceed with your matter. Yes.
Yes, yes.
19.
19th, Your Lordship.
19th. Let's finish it. It's been pending for too long.
Great.
Right.
2 p.m. Your Lordship, it's 2 p.m.
Yes, that's why we have looked for a day when we have that.
On your side, matter item number 1 and 2.
Before item number 1 and 2 starts, my lord, I would like to mention item number 3. Yesterday night, my lord, Mr. Bihani, who is appearing for the respondent, my lord, called me up, and he has requested to endorse the prayer for adjournment if it is made because his health condition is not well, my lord. So, my lord, kindly give a
It is in this list.
in this list. 3,
Item number 3, my lordship.
When-
I'm
when-
praying for 2 weeks' time, my lordship.
In third item, just recorded not. Both of you are there.
Yes, my
In
lord.
appearing
Sure.
item.
Yes, he has
A
expressed.
prayer is made for a of illness of the learned advocate representing.
My lord, in item number 3, my lord, I beg to appear on behalf of the state. My lord,
Please give your appearance.
we'll come back.
Item number 1, my lord, I am for the respondent's lead petitioner, and my lord, item number 2, my lord, I am for the appellant.
My lord, item number 2, my lord had directed me to file an affidavit. My lord, may I submit? It has been served to other side.
No,
Like to
fine.
the-
But I have not received any.
It has been served.
No, Iqbal Hussain, I am not Iqbal Hussain.
No, but they have received it. My clerk went yesterday.
Where is the copy?
I have written their chamber address and phone number, everything, my lord. Somebody has.
Point is, have they received or not? You may have written everything.
The notice says someone has received it from their chamber.
See, issuing of summons and receive of summons are two different things. You have sent it, whether they have received it.
I am requesting.
I shall
Can you give me one copy?
Give a copy.
Yes, yes. My lord, tomorrow I don't have extra copy. I shall submit within the course of the day then. But আমি কি করে move করবো?
So this is the opposition in the first case.
In the second.
Second case.
Yes. Which is a claim for interest, my lord.
Whatever it is.
First is my appeal, my lord, where I have challenged the payment of MMCC from the date of death without interest. Interest has been denied by the Honorable Single Bench. They have preferred an appeal.
Your appeal is practically infructuous because you have already recorded your stand in other cases that it is due from the date of.
My lord,
So issue is only for interest. That means
No, no, no.
whether they will get an interest or not. That is
No,
not
no.
issue.
The facts of this case is different. The deceased employee was not in the role when he died, and I
Very
have
well, then
challenged
we'll
based
see.
on that.
Then you give a copy.
My lord, I am supposed to give him a copy, but right now I have only one copy. I thought I have served it yesterday.
Very well, very well. My lord, let me start his my lord argument.
Yes.
My lord, in the meantime, I shall.
No. One day we'll finish.
Sir, share with.
Not piecemeal. What is it? There's hardly any issue. Why it should go over for 2 days?
No, I am not.
Both sides argue on one day. We don't want to prolong this like this.
And
Give a date.
my lord, should I come with the judgments and everything?
Everything, yes. What is it? See, the entire thing we have decided.
Yes, yes. No, the payment.
Yes, we have decided. Don't say no, we have decided. You may say you don't, that will not apply to you, but don't say no, we have decided.
Yes, my lord have passed and daughter. My lord,
Yes.
that is not the point here. It is a different.
So therefore, we'll just see whether it can be distinguished or not.
Yes. Yes.
So this is hardly anything, just give it to him, whatever you have to give. For exchange of some pleadings. We adjourn the matter. He doesn't.
I shall give it today only.
Please, yes.
Yes. Deeply obliged. এই নাম দিয়েছো? আমি ফোন করে নিচ্ছি। তোমার নাম্বারটা দাও। তোমার কি? হয়ে গেছে অ্যাডিশনাল। হ্যাঁ, নাম্বার এই দাও। 1 and 2. 1.
Item 23.
বলেছিল পরপর দুদিন হবে।
Lordship, item 23, I am beg to appear on behalf of the respondent bank led by Mr. Boydurju Ghoshal, Lordship. Lordship, due to his 23, Lordship.
22 order.
কিন্তু হয়ে গেল।
Lordship, I am praying for not this week, Lordship, as the advocate on record is not well, is not unable to come to the court, Lordship. I am praying for not this week, Lordship.
We had taken up this matter.
This matter was heard by my lord on last occasion.
That's what.
2 or 3 days. Issue is
Two charge memos.
2 charge memos.
Yes.
Issue is suspension order was issued on 20th December 2023. Thereafter, one charge sheet was issued pending adjudication or departmental proceedings, my lord.
Oh. So the first proceeding concluded, then second charge memo was issued. So suspension period for that suspension. When do you want it?
Lordship, not this week, only not.
As prayed by learned. Monday, give the date.
Monday.
Item 24.
Lord, I am for the petitioner. Lord, the order passed by the Honorable Single Bench would appear at page 81 of the application. Lord, may I just briefly place the facts of the case? And an application was initially made by the mother of the Lord, the petitioner, for compassionate appointment. Now that was rejected on the ground that the pro forma application was submitted beyond a reasonable period of time. And that was challenged in the writ petition. And the learned single judge considered that, but returned a finding on the ground that since the applicant himself was a minor at the time of the death of his father, the writ petition could not be allowed. And now, my lord, if I first place, my lord, the plain paper application that was made, my lord, on March 28, 2018. 2018 করা ছিল তো পড়াই যাচ্ছে
Respond.
the date of the date certificate would appear at page 33 of the stay application. And if your lordship takes the date certificate, the date of date is 8th of May 2016. My lord, the first application in plain paper was made.
What's your date of birth?
Lord, my date of birth.
Date of birth, actually.
1st February 2000. 2000. Well, I did not make the first application. My mother made the first application, which will appear at page 35. It is dated 28th of March 2018. And thereafter, at page 37, in 2019, Millard,
If I was the son, for her son, she
she made the application on behalf of,
her,
not for her.
her.
Within
Yes.
Yes,
taking majority within 2 years.
yes. No, on the date of death, he was minor
He has the option of making an application
within 2 years. Yes. So the observation of the learned judge, my lord, at the last annexure.
But taking majority of the state.
Data will calculate korate chalo. Millard, he attend.
1st of February 2018.
Yes.
Yes.
May 16.
May 16. Yes. But the rejection order is at page 81 of the.
By the opposition.
No, rejection order,
page 46.
Page 46.
Millard, I believe there was no opposition. It was
At the initial stage.
on the first day it was dismissed.
Yeah. 20th August. 3 August. 25.
25.
But it is with regard to that matter rounding of
169.5.
5.5
Male candidate.
a male candidate.
How many?
Malat single. Malat three petitioners. More than one. Malat this is একটা copy আছে. But here I think the certificate.
How many days of delay?
Malat in the application 190 days has been mentioned. Wait,
You have filed a certified copy of the order.
Lordship, not filed certified copy. Certified copy yet not filed.
Why, sir?
We applied for certified copy.
Yes, ওইটাই তো বলছি, ওইটাই দেখ। Malat the application has been filed. It has not been.
But it's not there on record. We have allowed him time to remove the defect. Yes, then how limitation is to be counted? Without certified copy, you have filed 190 days.
We already applied for please.
How can you proceed like this? There is no certified copy, there is no report on limitation. You filed an application for condonation. From where you have got the number of days, nobody knows. And you are representing Union of India.
The Lordship.
Wonderful. For taking steps in compliance with the
Grateful to Lordship.
That's why. But jaring এর ওইখানে।
Very inappropriately, may I submit one thing, my lord, with out of turn, my lord. Mr.
No, not right now. At the time of rising, call the list.
Item number 26. 26 to. Oh, 20. Item number 30.
Give. Why you are calling it? We already passed the order. Ah. Give the.
At 197.
None appears for the parties.
Item number 32.
Appellant Malad praying not this week.
Why? Give the file.
Mr. Ajinkor Mujumdar lead this matter. He's not well.
Give your appearance, madam. MS so and so.
$31 already order first. That's why Item 33. এটা 3 weeks তাহলে 20 আর ঠিক আছে item 34.
My lord, I beg to appear on behalf of the petition. My lord has recorded an order, my lord, on 27th April 2026 to take instruction, my lord. My lord, I do not have any knowledge, my lord, about this. But in Biman Bihari Thakur, my lord, regarding medical examination and police verification was in doubt, the honorable court. So, my lord, in that case, my lord, directed to consider.
That order judgment has been implemented by the respondents, or there is any appeal or SLP?
No, there is no appeal, my lord.
So it has been implemented.
I do not know, my lord, whether it has been implemented.
Delay of about 7 years.
My lord, my lord.
That is your case. And that delay is not attributable to you. We have recorded that it is covered by that judgment.
My lord.
So whether it was implemented or not, that's the only thing. You could also have found out. If you had that information right now, we could have proceeded. If they don't come, we will not repeatedly adjourn. There is none to represent the state again today. Let the learned advocate intimate the state. They have not filed any affidavit pursuant to that direction. Nothing.
Item number 35.
Item
Item 35, I appear on behalf of the petitioner, Your Lordship.
Yes.
Lordship, I'm led by Mr. Bishwaru Bhattacharya. He is in some difficulty, Your Lordships.
Not today.
I'm grateful, Your Lordship.
Item 36 to 41. 36 to 41.
My Lord, I'm for the petitioner on item number 38. I'm led by Mr. Fido Shamim. He's at court number 1. So I'm praying for not today.
Not today also.
Grateful, Your Lordship.
Item 42.
দুটো একসাথে না 42 42 একসাথে রয়েছে
Yes.
And for the appellant, Lordship, in nutshell, I want to express my Lordship. The appellant was engaged in the New Generation Commercial Bank in the year 2002, Lordship.
Bank.
It's IDBI Limited.
You're appearing in which matters? WPSC 77.
MAT 423 along with FMA 472. কোনটা আছে? 42. Item 43 একসাথে আছে। না। কোন দুটো একসাথে? 43 42 একাই আছে। 43 43. Oh, then not right. Apologize for that.
Item 43 and 44. I'll day. আরেকটা
You have repaginated.
The error was indicated in the year 2021, my Lord Justice Talukdar Lordship. Thereafter, the pagination was corrected and subsequently paper book has already been prepared, Lordship.
Paper book?
Has already been prepared and filed.
No, our last order we have allowed you to come.
Lordship, I have seen in the paper book and also in the brief, Lordship, that
already done.
Lordship, at that point of time, I.
Then let us see what's the order under appeal. We have not considered it earlier.
No, no, no. This honorable bench doesn't.
Yes. Yes.
May I proceed? Uh, the appellant petitioner was engaged in the new generation commercial bank in the year 2002, Lordship. Subsequently, that institution was merged with the IDBI Limited according to the scheme of amalgamation, which was passed and also affirmed by the Reserve Bank of India. And that was done under Section 49 of the Banking Regulation Act, Lordship. And in that scheme of amalgamation, Lordship, it was categorically and specifically mentioned that no such compartment was will be created in regarding interstate seniority, Lordship, or for the purpose of promotion, Lordship. But that was not done, and the interstate seniority of the appellant petitioner was manipulated, for which the petitioner, when was promoted in Kolkata, at Kolkata, Lordship. Since then, Lordship, the appellant petitioner made several representations before the various authority of the bank also, and also the government of India, Lordship. At that point of time, no such relief was granted in favor of the petitioner. Petitioner made petition before this honorable court and defeated on the grounds of delay. He went to division bench and subsequently before the honorable apex court, but that was not considered. Thereafter, the HR department, Lordship, the Union of India issued one advisory to the bank, indicating that there is some grievances of the appellant petitioner. And that advisory was not considered by the bank. Petitioner preferred one writ application before this honorable court for compliance of that advisory. This honorable court, while hearing of that matter, the bank authority handed over a compliance report to the petitioner, and this honorable court, the single bench, granted liberty to petitioner to approach after going through the reply. Thereafter, the petitioner considered that that compliance report is not according to the advisory. Advisory was issued by the Union of India. He preferred another writ application, and while considering that writ application, this honorable court considered that there is lack of territorial jurisdiction. He preferred this appeal of FMA 472. Pending that appeal, there is a change in the management of the IDBI, and LIC came into the picture, having 51% share over the management. And after that, they started one show cause notice and disciplinary proceedings was generated prior to 5 days before the retirement of the petitioner. That disciplinary proceedings was challenged before this honorable court, and this honorable court considered that IDBI is no longer a public entity and transferred into a private institution, as because government is not holding more than 50% share. So on the demerger issue, that writ was dismissed. And challenging that order, the appeal of MET 423 of 2021 preferred by this appellant lordship.
Where in this order it has been stated that because it is a private entity, that it is not maintainable. Please read from the impugned order.
No, lordship, it is not as it is not indicated that is a
What are you arguing, sir? There is not a whisper in the order about this.
No, this is not private entity as say.
You just
but
now said that
read
it was
this-
dismissed because they,
I pardon.
what
lordship.
is this? You
I
make
pardon-
any submission.
No, I pardon, lordship. As
Whether
because-
it is from the record or not, you will just say it.
No, lordship. I beg pardon, lordship. But on the maintainability ground, as it is not
Very
a
unfortunate. A 3-page order and you are making an incorrect submission.
I beg pardon, lordship.
You should. This is not the way to assist the court. Yes, come to the issue which has been decided. Don't say things which are not there in the record.
The dog.
Volume 3 is the impugned judgment, lordship. 3.
No, where is 24592 order? Earlier writ petition 24592. Decided by the Calcutta High Court. WP number 24592 or MAT 706 of 17. 24592 is of 16.
16. Oh, initially. No, হ্যাঁ that will be. No, এটা first এটা দাও first volume দুটো কোথায় গেল? ও এই তো volume 1 এটা হচ্ছে ইউনিটি। This is the volume 1, lordship, starting from page 170. Presently, that is now 170. 175. Lordship is asking for the 2016 judgment order. Lordship.
Yes, 24592 of 16. How more specific can we be?
Volume 2 पे था। Nine, 16 order ছিল তাহলে এইটার ভলিউমে থাকবে। ভলিউম ওয়ানটা কোথায়, এটা সেকেন্ডটা?
Page 333, Lordship. Volume 2, page 333.
ও আচ্ছা, এটা রিপের সঙ্গে অ্যানেক্সড হয়ে রয়েছে এখানটা। না, এটা তো ভলিউম ওয়ান ভলিউম টু, এটা ভলিউম ওয়ান ভলিউম টু আছে। ফাইভ এর 3 2 1 টু পরপর এটাই আছে না, এটা আছে, এটা আগেরটা। চারশো বার 472 2021 472 2021।
Now, where is the rejection by the head office? Subsequent rejection by the head office. Noted in first paragraph of page 3 of the impugned order, which he claims to be the fresh cause of action. Perhaps it is of 1/2/2019. The date is not mentioned in the order.
Department.
You don't know where your impugned order is.
Lordship, asking for the impugned order of which
The impugned order which you challenge in the writ petition, sir. You are the writ petitioner.
Lordship, in that writ petition, Lordship, we challenge not only the order, the
Bother to read the brief. That is the problem. You have not bothered to read the brief. You started off making wrong submissions.
that impugned order is starting from page 174 of volume 1.
No, it is not. You please come to page 101. Don't read anything. What is your first prayer in the writ petition? Please see. You should be telling us, we are asking you, we are pointing out everything. And you are making wrong submissions on facts. Very difficult. You are not prepared. Not today. Very unfortunate. You don't know the head and tail of your case. What to do, we don't know.
Item 45. No. Item. No, not 45. Item 26 to 29.
Other matters, continue, I think.
Let's see, we don't know. Yes.
Yes. My lord, before your lordship takes up the hearing, my lord, very reluctantly, my lord, I should draw your lordship's kind attention to the inconvenience that is being caused in this court. Lordship will kindly say this. The entire space has been occupied by the briefs. Neither the lawyers can sit, nor the litigant forever. I know, my lord, the dearth of place and accommodation in this, but at least this may be freed. Anyway, my lord, I believe your lordship has taken note of it.
Yes.
Well, so far my case is concerned, my lord, there are altogether four. There are altogether four matters, my lord, of the same nature, my lord, which has started as back as in the year 1984.
Yes.
1984. My lord, writ petition was filed. Then the writ petition was transferred to the administrative tribunal, state administrative tribunal.
For 95.
Yes. Well, the main writ petition was filed, that was in 1984. And then, my lord, there are so many writ petitions. There are four, and four writ petitions were transferred to the administrative tribunal. Lordship will kindly, if your lordship kindly gets, my lord, my application, that is WPST 256 of 2014.
We have it before us.
Yes. Lordship kindly straightway goes to page 20.
256. 256. Give 256.
Yes. একটু দেখিয়ে দিন, একটু বের করে দিন। WPST 256. Very difficult to handle. It's a big one. But for my convenience, I have just made it a part. In four parts, I have done it. 256 of 2014. চারটে ফাইল হবে।
Six transfer applications were disposed of by one order.
All applications were disposed. I am taking up, my lordship is taking up WPST 256 of 2014.
Yes.
Yes. My lordship kindly goes to page 15. Page 15.
Yes.
Paragraph 4. Now I am giving the brief history of the case. Page 15.
Page 50 is a cause title of the writ petition. No, what is it? Annexure
WPSC number 256.
Annexure P1, page 50 is not part of any pleading.
Page 15, your lordship, 15.
15.
Yes, your lordship.
15.
Sorry.
15.
50.
Yes.
Yes. Paragraph 4.
Paragraph 4.
Yes.
Originally, a writ petition was moved before this honorable court, challenging the order bearing number so and so. And this number is an annexure E at page 88. And the order bearing memo number so and so, issued by the chief engineer, which is registered at CR number 13193. And this honorable court was pleased to issue a rule and was further pleased to grant interim order in terms of prayer D of the writ petition till disposal of the rule. I'm not paying the prayers, my lord. Page 18. The said writ, page 18, paragraph 6. Said writ petition was transferred to the learned West Bengal State Administrative Tribunal as TA number 74 of 2001. A state filed reply on the basis of the leave. That is also not necessary. Then your lordship goes to page 19. Page 19. Paragraph 10. Your petitioners herein, along with some other person, also moved another writ application challenging the purported order of withdrawal of the scale of pay of rupees 365, and the said application was registered at so and so. And this honorable court was pleased to grant a stay of operation of the said order, which is under challenge in the said writ application till the disposal of the writ application. Page 19, your lordship got it. Paragraph 10.
10.
Yes. What I am trying, my endeavor is, my lord, to draw your lordship's kind attention that the dispute is over this pay of rupees 306.85 to the petitioners, which, my lord, the state contends that we are not entitled, and we say under the rule we are entitled. That is one of the disputes. The other dispute is, my lord, as my lord, your lordship further proceeds, and your lordship asks me to further proceed. The controversy was as to what was the educational qualification, academic qualification of this applicant at the time of their recruitment. But if the state say that it should be school final, whereas it is said in some rule, it is said that minimum qualification is class 8. Although all of your petitioners before your lordships, they are school final candidates.
School final.
School final. Some matriculates, even some graduates are also there.
So that is one of the issues in controversy, whether
That
it
is one of the
is
issue.
S8.
What is the educational qualification of these employees who are the names?
So this grant of this scale should be linked to that.
Pump operators, yes.
It will be linked to that, or it will be a
I'll
separate.
come to that, my lord.
Yes.
Yes. But the matter has gone even up to the Supreme Court. And the Supreme Court has also delivered a judgment.
And can you just tell us which post is involved? They are working on which post?
Yes, pump operator. Pump operator in the river lift irrigation scheme.
Some
Pump
irrigation
operator
scheme.
in the river lift irrigation scheme. Now, in page 20, your lordship, I am straightway coming to what is my case. At page 20, your lordship kindly comes. Paragraph 13. It is better I placed paragraph 12 to get hold of the entire, my lord, the case history. Against the withdrawal of a scale of pay of 306.85 granted to the petitioners in view of the interim orders CR 11478 and CR 4 writ applications were moved, being so and so. All the aforesaid writ applications were subsequently transferred to the West Bengal Administrative Tribunal and were registered at TA 3, 4, 5 and 6 of 2008. Now, all these writ applications, being the transferred applications, were heard together. That is paragraph 13. All the aforesaid writ applications which were subsequently transferred and renumbered respectively were finally heard by the second bench of the learned tribunal, consisting of the Honorable Justice Shyamol Kanti Chakraborty, Chairman in charge, and Honorable Mr. Somar Ghosh, member, analogously, and delivered the judgments on September 27. After hearing, their lordships were pleased to hold. It is just something has been gained, my lord. The judgment is quite a big one, and my lord, your lordship will kindly allow me to place their judgment thoroughly, because the judgment is totally based upon a writ petition which your lordships are not sitting on it. It was a judgment given in another writ application. That was also heard by the learned tribunal, and that judgment was relied in order to dismiss our writ application.
Different applicants there.
Pardon, my lord?
Applicants were different or same applicants?
No, that is not same applicant. Other applicant. It was altogether a separate person. Well, here it is said, we do not find any illegality or infirmity in the order bearing number so and so, and the order bearing number so and so, and as such, we do not want to interfere with these orders. Accordingly, the said orders also be applicable to the petitioners, and they shall be subjected to all conditions so and so. All these applications were dismissed. Now, my lord, your lordship is on page 21. Page 21.
Yes.
Yes. In the said judgment, their lordships also ordered. The petitioners are enjoying the benefit of higher scale of pay in terms of the interim orders of the High Court, subject to the result of the application and on the undertaking that in the event the writ petition fails, the excess amounts so paid will be adjusted against the salary of the petitioners that may be payable in future or against the retiring benefits as the case may be, and the petitioner will not raise any objection thereto. In view of this position and the order dated 7/9, the Honorable Supreme Court, Dr. C, the Honorable Supreme Court, here comes the Honorable Supreme Court. In so and so, the respondents shall now be within their rights to recover from the petitioners the amount drawn in excess of 8/9 so and so, in terms of the interim orders of the Honorable by applying the order number so and so dated, read with so and so dated so and so. Now that was, my lord. After this one, my lord, the writ application was taken. We have taken away the writ application. What is our writ application? My, that your lordship will kindly find our writ application wherein we have narrated our case, our pains and pain, the penalties which we have been suffering. Now, your lordship kindly goes through. Our writ application is we have annexed. The one. It is at page 44. There are a number of petitioners. That is why actually the content starts. Yes. At page 62. With the lordship's kindly, my lord, I am placing this petition. Because in this petition, my lord, we have narrated our case. Petitioners are the employee in the post of assistant operators under block development officer different station under the Directorate of Agriculture and Engineering Government of West Bengal. The petitioners are under the control of the respondent number 2. How they were recruited? Petitioners, after the successful completion of their training for the post of assistant operator, were selected for appointment in the post of the assistant operators. And since then, your petitioners have been carrying on their function as the assistant operator with sincerity, and your petitioners were appointed in the aforesaid position on different dates, having requisite qualification. Having requisite qualification as provided in the circular dated July 30th, 1973, issued by the respondent number 2. What is the July circular, ma'am? Lordship kindly finds that at page 81. At page 81. The entire saga started from this. Your lordship now will find every alternate day circulars were being issued. Now it is recalled, again reintroduced, now recalled, again reintroduced. It is like that. I don't know whether there was any Mohammed bin Tool over there. My lord. This is a circular. Essential for appointment to the post of assistant operator under RLI scheme and water transmission assistant under Department of Fuel Irrigation scheme. Considering the duties and responsibilities attached to the post of the government have since been moved for upward revision of the pay scale of the assistant operator under river lift irrigation scheme and water transmission assistant under deep fuel irrigation scheme. For the same reason, it is considered necessary that general educational qualification of the candidates for appointment to these categories of posts should be raised. Accordingly, it is decided that candidates for appointment to these posts of assistant operators under RLI scheme and water transmission assistant under deep fuel irrigation scheme must be, Lordship says must be passed in a school final examination or its equivalent, that is passed 10th class of higher secondary course or passed higher madrasa examination. It is therefore impressed upon the chairman of the Central Selection Committee and different appointing authorities that they should neither select nor appoint any candidate who does not possess the above prescribed minimum general educational qualification for appointment to the posts concerned. The other requirements will remain unchanged. It's all right, so educational qualification raised. But what I want to bring to your lordship's kind attention is the next paragraph. That is very important. This will not, however, apply to the appointment already or yet to be made on the basis of the clearance issued prior to issue of this circular. What is the date? The date is 30th July 73.
Is it? Please have a look at paragraph 3, which you just read at page 62.
At 32.
Page 62, you read paragraph 3.
Yeah.
Just the last line of that paragraph, please have a look.
July 30, 1973.
4. Here it is 4, and there it is 3. So which is the correct date?
Yes, paragraph 4.
No,
At
it is
62?
July 30th, 1974.
No, it is 73.
73.
It is 73. It's a typographical mistake.
Very well.
73. A first submission before your lordship that we have to take a note, subject to your lordship's approval, that well, the government has the liberty. They can raise the educational qualification. But since, my lord, some appointments have already been made, some appointments were already been made, to which category we belong to. The government took a note and very cautiously said, this will not, however, apply to the appointment already or yet to be made on the basis of the clearance issued prior to issue of this circular. Therefore, before the issuance of the circular, if any appointment is made, it is not going to be disturbed. And who we are? My lord, at page 62, we have already said in paragraph 3. We have already said that. After successful completion of their training for the post of assistant operator was selected in the post of assistant operator, and since then your petitioners have been carrying on their function as the assistant operator with sincerity, so and so. We have already said that we have been working as an assistant operator. So this is what it is. Now, thereafter what happened? Thereafter, my lord, your lordship sees, my lord. Yes. Your lordship now kindly goes to page 83. The game started.
Yes.
Yes.
So you were appointed prior to this 73 circular?
Pardon, my lord?
You were appointed prior to this 73 circular?
Yes. This. We have not getting the salary. It is after the revision of pay. My lord, the pay that was revised, my lord, from 360 to something.
Have they said in the writ petition that they were appointed prior to this circular?
They have given reply also. Reply that. So, my lord, as to how the entire thing has been dealt with at the level of the government. Now, this is the my lord, your lordship. I will beseech your lordship to kindly keep it in mind that if appointment have already been made, it will not be disturbed. In so far as the educational qualification is concerned. Educational qualification is concerned. I am not on the scale of pay. On the educational qualification, should it be master school final or something else? Master school final is 1973. It is not denied by them that we are already working when this particular thing comes. This 73. It's not denied. It is not denied. Now, my lord, then your lordship, I'll take your lordship, my lord. Your lordship will kindly take page 83, Annexure B. Annexure B. Page 83 is dated, your lordship find page 83 is dated 6th November 1981. 6th November 1981. Now, what is the sanctity of this 1981? What is the sanctity of this 1981? In exercise of the power conferred by the provision of Article 309, the Governor is pleased to make the following amendments in the West Bengal Service Revision of Pay and Allowances Rules, published with the finance notification. Now, my lord, how the pay revision was made? By virtue of a rule. The rule is called, my lord, the Revision of Pay and Allowances Rules 1981. Copy আছে। My lord, I will place this rules এখানে দাঁড়াও। এরকম করে দাও, দাঁড়ান খুলে দাও। This is revision of pay. Revision of pay and allowances rules.
You have given him. Have you given him a copy?
It's a rule. I have a copy, my lord. I have to make another.
We understand what you are saying, but
Oh, certainly. Certainly. I shall give you a copy. My lord. Now, my lord, in page 84, your lordship finds, just at the bottom, after division, it becomes 330 to 550, 380 to 910. But it is not applicable in our case. It is at page 85, which is applicable.
if SF passed.
Yes, if SF passed is the minimum educational qualification required for recruitment, rupees 306.85. If SF passed, then required is 306.85. 685. No, SF passed is something which was introduced in 73. It does not rostrum when the rule was framed. Because we are entitled to get it. The benefit of the rule that has been framed. And if the revision has been made. Yes. Yes. My lord, the revision is made, my lord, your lordship takes up, my lord, that rule I have given.
Yes.
Page 31, your lordship kindly sees it. Pump operator. Lordship kindly gives you a moment, my lord. Lordship kindly gives me a moment, my lord. You see. It has a leakage in assistant operator. Page 27. Page 29. Yes. ভেঙে যাচ্ছে আপনার ওই সম্পদটাকে ওখানে রাখুন না এখানে দাঁড়ান
Maybe at page 28, maybe
it may be 29 yes
28, maybe.
yes 29
29.
assistant operator
No, you said you are operators.
assistant operator
You are assistant operators or pump operators.
assistant operator.
Post involved is assistant operator.
Assistant
They
operator.
are assistant operators. Then 29. Operators are at 28.
Page 29 yes
Yes.
assistant operator page 29 that of the revised scale was 245 to 455
455, yes.
245 to 455 yes now your lordship kindly goes to page 31 আপনার ওই সম্পদটা ওখানে রাখুন না Pump operator. Pump operator. Pump operator. Yes. Mechanic cum pump operator. আপনি তো মেকানিক কাম পাম্প অপারেটর স্টেশন অপারেটর সেটা এখানে এটা না এটা না yes therefore my dear lordship that water transmission assistant or assistant operator at page 29 245 455 this is the rule this rule now this is with regard to the pay.
This is fixation after the recommendation of the pay revision.
Yes. This is with regard to the pay. But what about the qualification? The qualification, well, here it is said if school final, then the pay will be different. If school final, the pay will be, that is That is at least overtly from this rule it appears. If school final,
So which is later, this or that
that is in 81.
notification is later?
Yes.
Both are of 1981.
We were recruited long before. Even before 73. That is why, my lord, the government contemplated that already made. So far as their qualification is concerned, that qualification of school final will not be applicable. That is why it is said, my lord. At page 82, this will not, however, apply to the appointment already made. Because in 1973, government decides that, well, educational qualification will have to be raised. Page 29. Page 29. Page 29 too. Assistant operator. In page 85, my lord, in subparagraph 2, it is said, otherwise, the revised scale of pay. Residual 2, otherwise, if essay passed in the educational qualification, required for recruitment rupees 300 and 685, otherwise the revised scale of pay.
That means 245 to 455.
Yes. 245 to 465, that is it is.
Otherwise this.
Yes, otherwise this. Sorry. Yes. Yes. Thereafter, my lord, your lordship kindly goes to. I have shown this annexure B. Yes. Your lordship goes to page 86. Page 86. Page 86 is of 1974. Page 86 is of 1974.
Yes.
The proposal of change of pay scale of assistant operator and water transmission assistants have not yet been finalized by the government. As such, the proposed recruitment rule may not be enforced for appointment water transmission assistant operator. Circular issued by so and so is hereby withdrawn. That is annexure A, page 81. Page 81 is withdrawn. It is withdrawn. When? In 1974. Well, you have a right to withdraw. But what happens? This will not, however, apply to the appointment already made. What will be their fate? If it is withdrawn? at page 86. My lord, in my humble way, I try to reconcile the whole thing. But later on, the next paragraph.
It is valid for 13 months.
Yes. 30th August 1974. It is. The next, my lord, paragraph.
Yes.
Circular issued, that is withdrawn, that is page 86, page 81, that is withdrawn. So I raised this question. Well, you have withdrawn it, but what about those who have already been given appointment? What is their fate? So far as the educational qualification. Because you say that pay should commensurate with the educational qualification. But you have already withdrawn it. But we are there. Not only this, then my lord, this circular so and so. It is therefore, my lord, it is by the Chief Engineer Agriculture West Bengal. It is therefore impressed upon the chairman of selection committee and different appointing authorities to follow the previous recruitment rules. Now, what is these previous recruitment rules, Mullah? I have tried to find out. I couldn't get it. It is only this learned Chief Engineer of Agriculture, he can say. Previous recruitment rules in respect of appointment and water transfer in the matter of selection. If the previous recruitment rule, my lord, that holds the field, in the previous recruitment rule, not before 73, educational qualification was raised? No? Educational qualification you have raised in 1973. Therefore, what is the previous, what is your previous recruitment rules? That previous recruitment rule we wanted to know. What is the previous recruitment rule? Well, the answer is not with them. It is with us. What is the previous recruitment rule? However, therefore, my lord, I will place it before your lordship. I have those copies. The previous recruitment rule. So that will follow. This is in 1974. The previous recruitment rule follows. This is all regarding educational qualification, my lord. Much rigmarole was there. Your lordship goes to the next page. On to the next page. This is again the chief engineer. My lord, the early one your lordship was seeing, my lord, that was of 1974. And this is of 1982. This is of 1982. My lord, here it is said, in pursuance of the AD 61181, the undersigned would state that the assistant operator recruitment for RLI stations in terms of circular dated 30th July 1973, which is at page 82, my lord, your lordship has seen, shall get the revised scale of pay 300, 685. This is in 1982. So, my lord, this is a decision. The pay of such assistant operator may be fixed in the scale of pay 300 and 685 if they fulfill the term and conditions as laid down in FD 6/11/1981. That is at 83, page 83. Yes. It is at page 83, which is updated 81. Division of pay and allowances rules. Then your lordship goes to page 88. Again, something happened. At page 88. Order issued under this is of 1982. Lordship, this is of 1982. Order issued under this office dated 12/2/1982. It is just after 12 and this is 23. It is just after 11 days. Just after 11 days. Order issued conveying the order for fixation of the assistant so in the scale of 306 is hereby cancelled. It is cancelled. Then something else happened again. That is at page 89. At page 89. In pursuance of FD memo noted so and so, the undersigned would like to state that the assistant water transmission assistant recruited for the RLI and deep well stations in terms of circular issued of this office on 30th July 1973 shall get the revised basic scale 300 to 685, where the incumbents are SA pass or equivalent. The pay of such assistant operators may be fixed in the scale of pay 300 and 685 if they fulfill the terms and conditions laid down dated 6/11/81. This order supersedes this office does so and so. So this is all. So this is 2382. Your lordship says, but that also has been revoked thereafter. Lordship finds that is at Annexure G at page 90. This office order dated 2382 allowing a scale of pay 300/685 for the post of assistant operator and water transmission assistant at this rate is hereby cancelled. Is hereby cancelled. Therefore, my lord, this is all with regard to it is linked up with the educational qualification and the scale of pay that they are going to look at. Now the question is, what is the minimum qualification for those who were recruited earlier? You tell it to the court. What are the minimum qualification? What we have stated that we have very categorically said how we were recruited. Yes. My lord, in our applications, we have stated that, as your lordship has noted it.
Page 62 perhaps? Page 62.
No, page 62 is there. Yes, page 62.
In paragraph 3 you have stated.
Yes, page 62. Page 63. In the circular, it was in the circular July 1973. Pursuant to that, that is at page 81 and 82.
Yes.
Page 81 and 82. My lord.
So you are claiming to have SF.
Already they have exempted. You have given that exemption. These will not, however, apply to the appointment. The post is same. The rank is same. The service is same. Now, how come that if you go on changing, rechanging, recalling, then reintroducing, initially, if you go on saying, well, you have. But our educational qualification at the time of recruitment, because we were competent, and we had to undergo a particular process of training, as we have said that. After training, we have been given that appointment. Not that we are not eligible for giving an appointment. So eligibility is not only the training, there was an educational qualification. That educational qualification, if it is school final, we have categorically stated that we are all school final. Even somebody else, some people are even graduates, which has not been denied. This is how it has been said. So, my lord, this is, my lord, how the entire thing has gone. Now, with regard to these applications, my lord, in this application, your lordship will kindly see. I will take your lordship's final liberty to place as to how our application was dismissed. Yes. At page 22, your lordship will kindly go. At page 22. Paragraph 16. Paragraph 15, my lord. After going through the judgment, it appeared that the learned tribunal totally based the judgment of the Honorable Division Bench as well as the Honorable Supreme Court. Well, your lordship finds two things. One is Honorable Division Bench, the learned tribunal relied upon, and the other one is as well Supreme Court. But not on the basis of the argument of the learned advocate as such the entire judgment, so and so. What I am trying to show before your lordship is that the learned tribunal, my lord, while disposing of or dismissing our applications, original application, relied upon these two particular judgments. One, the division bench of this honorable court, and the other one of the Supreme Court. What is that? The next paragraph. The learned tribunal, though, recorded that all the incumbents are school final. Not my saying. It is not my saying. The tribunal is saying, they are finding. The learned tribunal, though, recorded that all the incumbents are school final pass or equivalent and all of them fulfill The terms and conditions are laid down by the Finance Department section, but in spite of that, dismiss the application on the ground that in the similar application in the name of one Shailesh Kumar Singh Orai. One Shailesh Kumar Singh Orai, he is not here before your lordship. Neither we were parties in that Shailesh Kumar Singh Orai. Neither we are parties. Shailesh Kumar, the Honorable Division Bench of the Honorable Court dismissed the said writ application, which is appointed by the Honorable Supreme Court, and the learned tribunal could not come out from the cloak of the judgment of the Honorable Division passed in Shailesh Kumar Singh, which is appointed by the Honorable Supreme Court of India. Therefore, my lord, the sum and bonum of the whole thing is, my lord, all the applications were dismissed, relying upon one division bench judgment and a judgment delivered by the Supreme Court in Shailesh Kumar Singh. Who the gentleman was, we don't know. Neither we are a party, nor you are included of the party. But the tribunal heavily relied upon that judgment. My lord, your lordship has to see that judgment. Shailesh Kumar Singh. Yes. My lord, unfortunately, that judgment has not been I am just hovering around still now. My Your Lordship will kindly pardon me, because it is a very old matter and a very complicated matter. Once introduced, the next day recalled, then introduced, the next day recalled, and all these matters. So in this juxtaposition, my lord, I have to go through. Now the thing is, my lord, the judgment which the learned tribunal, the order rather, the final order, which the tribunal had made, my lord, that was the order dated 25th of September 2014. 25th of September 2014.
Division bench.
It is such a, yes, tribunal, against which we have come. My lord, this is the judgment. It's quite a bulky one.
That certified copy we have.
It is there, my lord. Your lordship will finally, my lord.
The certified copy is there.
498.
Yes.
Yes, at page 498. At page 498. Yes. It is a 39-page judgment. And my lord, the judgment which was relied upon by the learned tribunal, a division bench judgment of this honorable court, your lordship will find it at page 117. 117. 117. At page 117. Justice Chittotor Mujumdar and Shamsuddin Ahmad. The judgment है कुछ है टॉयलेट कुमार है मैंने so far as just Shailesh Kumar judgment, my lord. I have to find it out. Yes. My lord, the judgment was, this is, your lordship has got it, my lord, 498, the judgment of the tribunal. 498, yes. Polish Kumar judgment, huh? Yes. My lord, Polish Kumar, that judgment your lordship will find, my lord, at page 117. At page 117. At page 117. My lord, would it be, I'm just asking myself, my lord, whether I should paste the judgment which include, my lord, the order, the final order of the tribunal. The final order of the tribunal that has been much relied upon this judgment also.
Silence judgment.
Yes. So, my lord, Shailesh. So, my lord, could I please, my lord, first the judgment which is I have indicated.
The tribunal judgment under
Yes, tribunal
consideration in the present.
It's quite a big one. Yes. May I place it, my lord? Will you place it, my lord?
If you want to.
My lord, I want to place it because, my lord, this judgment has been, my lord, very much challenged before your lordship for your kind of consideration as to whether this judgment actually applicable in our case, legally applicable in our case, or it can at all be relied upon. That is how, my lord, we have built our case before your lordship.
So, if we have understood correctly, you are saying the tribunal relied upon division bench judgment in Sailesh case. You were neither parties there, nor anyone from that case is here in this.
We had no opportunity to deal with.
So whether in terms of that judgment, the tribunal could have disposed of your case or not, that is the issue.
That is also a case. That is also a case. That is one. That it is a case in which we had no opportunity to make our submission. One. The second is, well, Shailesh, the factual event of Shailesh Kumar is altogether different. His recruitment, our recruitment in complete in a different manner.
So that we can find out from Sailesh judgment or the tribunal judgment, that we are trying to understand.
No, but since, my lord, the learned tribunal is relying upon the judgment of Shailesh, Shailesh, in that case, my lord, we didn't have the opportunity to make our submission. We couldn't take the point that, well, this gentleman is altogether different footing than what we are. How come that you can equate us with an unequal one? The issue is that is a question of the pay commensurate with the recruit, commensurate with the educational qualification at the time of recruitment, the mode and manner of the recruitment, the particular law, particular rule under which we are recruited, and the particular rule under which Shailesh was recruited.
Yes.
Yes. Could I further proceed, my lord, today?
Yes.
Yes. So I'm placing the judgment, the final order. The final order, which I've carried, yes. Yes. My dear Lordship sees, my lord. It starts as internal page 3, paragraph 2. Paragraph 2. My lord, the learned tribunal takes up 6 matters. Of the 6, 4 were passed and 2 some other persons. 2 some other persons. 6 petitions. My dear Lordship sees, my lord, the number 13193 is ours. 11478 hours, 13570 is ours, 1313572 is ours, 13573, 13556, so and so. Yes. 6 writ petitions being so and so were filed before the Honorable High Court, Calcutta in different years by a large number of assistants who are working under the erstwhile Director of Agricultural Engineering. Since renamed as Water Resources Directorate, primarily claiming the scale of pay of rupees 300,685 as prescribed by the WBS ROPA rules of 1981. These writ petitions were eventually transferred to the West Bengal Administrative Tribunal and renumbered as TA 74, TA 264, TA 3, TA 4, TA 5, and TA 6, respectively. The contention of the petitioners in all this application was that after completion of training, after successful completion of training, Lordship will kindly mark, after successful completion of training for the post of assistant operator, they were selected for appointment in the post of assistant operator on different dates, having requisite qualification as provided in circular number July 30th, 1973, issued by the Chief Engineer, West Bengal. My lord, this July 33, 1973 circular, my lord, your lordship, this is, my lord, at page 38. At page 38, this circular is there. According to the said circular, the minimum qualification for appointment to the post of assistant was a school formal examination or its equivalent. Some of the petitioners passed SAP examination, some had passed higher secondary examination, some are graduates. Government of West Bengal revised the pay scale, second pay commission by notification dated July 81 by framing West Bengal Services ROPA Rules 1981 in exercise of the power conferred on Article 309. The said rules were amended by notification dated November 6, 1981. By this amendment, the revised scale of pay of a post for which passing SAP examination minimum educational qualification required for the prescribed was 306.85. Otherwise, the scale of pay shall be shown in the schedule and so against the particular post. By issuing a circular under memo dated so and so, the circular issued under memo number so and so dated 30 July 73 was withdrawn, stating that the proposed change of pay scale of assistant operators had not yet been finalized by the government. As such, the proposed recruitment rules may not be enforced for appointing water transmission assistant and assistant operator. Again, under memo dated 12 February 1982, the chief engineer issued an order stating that pursuant to the finance department memo dated 6 November 1981, the assistant operators recruited for in terms of circular issued under office order dated so and so shall get the revised scale of pay, where the incumbents are SF past and equivalent. It was further mentioned the said order pay of assistant operator may further mention that the pay of the assistant operator may be fixed in the scale of 365 if they fulfill the term or condition finance department memo dated 6/11/81. Thereafter, another order was issued by the chief engineer stating that the order issued conveying the order of fixation of pay assistant operator under directorate of the scale of 300/600 was cancelled. Subsequent to the issue of order dated 23rd February 1982, respondent number refused to allow the petitioner to draw pay in the scale of 365 on the ground that the petitioner did not comply with the provision of the aforesaid notification dated 6/11/1981. The petitioners have alleged that when in terms of the provision is amended, they were entitled to the scale of pay 365. Respondent number 3 was not competent to alter the provision. But if school final is the criteria for getting a pay scale of 300 685, if somebody else is school final, admittedly we are school final, why should we not get the benefit there? Admittedly, it is forget about all this the notification. Subject to your lordship confirmation that it is we are school final. Our qualification is this, and if this is our qualification, 73, 74, 80, 70, so and so. Now under 81 rule, if it's school final, then 306/85. It is there. Well, at this point, my lord, I will bring home for your lordship's kind consideration. The condition of serving the petitioner had already been determined and subsequently could not be altered respectively to the prejudice of the petitioners. I make it a point, my lord, for your lordship's condition. They had then another order issued by the chief engineer superseding the earlier orders issued under memo dated so and so, dated 12/2/1980, stating that assistant operator or water transmission assistant recruited RLI deep well station in terms of the circular 713 shall get the revised basic pay of 306/85. Sometimes confirmed, sometimes withdrawn. Well, are they, my lord, whether the department was really at a stage to consider as to what should be the pay? If the rule has prescribed an educational qualification, if the rule has prescribed a particular pay scale, if we qualify, no question whether whatever notification were issued or not, I have shown this in order to show that it is in a Tughlaqi way the department was acting. Now, after 2 days, another order was issued so and so. Tribunal is some assistant operators now comes. Some assistant operators, Shailesh Kumar Singh Rai and others working under different block department officer moved a writ petition under Article 226. Honorable Justice Ashamukul Pal, as his lordship then was, delivered a judgment on 28/4/1983, directing the respondent to allow them the benefit scale of 306/85 as prayed for and revise their pay and allowances in the said scale with area of pay and allowances. The petitioners not being parties to the said petition were deprived of the benefit of the judgment. They accordingly filed 2 other writ petitions, being share number so and so. Praying inter alia, writ in the nature of mandamus, all this, identity order so and so. By all, should proceed, madam. By order dated 20th December 83, His Lordship Justice C.K. Banerjee, as His Lordship then was, granted interim order of injunction in terms of paragraph 25D of the petition till the useful liberty to the respondent to apply for bearing or vacating the interim order. They never came for bearing or vacating the interim order. The petitioners so and so made similar pairs. In that case, by order dated Honorable Justice Ajit Kumar Sengupta, as His Lordship then was, granted interim order of injunction in terms of prayer 30D of the petition till the disposal of the rule, having regard to the judgment of the single bench in High Court by the division bench appeal against so and so. Thereafter, certain developments had taken place. In the judgment of so and so, Justice Ashamukul Pal, as His Lordship then was, it was held that a recruitment qualification for the post of assistant operator was passed in SF examination, and therefore the assistant operators were entitled to the scale of pay of 306.85 in terms of WPS ROPA Rules 1981. The state filed an appeal before the division bench of the Honorable High Court. Being FMA number of so and so, and the Honorable Division Bench set aside the judgment of the single bench and held categorically that recruitment qualification for the post of operator was reading up to class 8 standard, and therefore the assistant operators were not entitled to the scale of pay of 306.85. This is what the division bench said. Now, my lord, it is said the set aside the judgment had category held that the recruitment qualification of the post of appointment was reading up to class 8 standard. Yes, it was class 8 standard at once upon a time. But we are not class 8 standard. We are school final. Against the judgment of the division bench, the Honorable High Court SLP was filed with the aggrieved party, which was admitted and converted into so and so. They said the civil appeal, along with civil appeal being number so and so, the Honorable Supreme Court, upholding the decision of the division bench of the High Court and dismissing the civil appeals. But what was the issue before the division bench of this Honorable Court? The issue was completely different. Was totally different. So, the moment we go further, it will be quite clear the division bench was considering as to whether a notification is necessary to give effect to an amendment of a rule. That was not our case. Justice Chittatur Mukherjee, my teacher, my lord, yes. I was his student. With deep respect, my lord, the question was altogether different issue. I'm not harping on that issue. I'm not harping. Whether that was correct or not is a constitutional question. Whether there was any provision that even without issuing any rule, even without issuing any notification or with the consent of the governor, whether a rule can be amended or not. That is altogether a different issue. I'll take your lordship to the constitutional provision to that. But this is what it is said. My lord, review petition were filed by the civil appeal, that was also dismissed. 4 writ petition being so and so. As mentioned, 33 petitioners of CA number so and so are also petitioners in C and 52 petitioners in so number so. These are all not necessary, my lord. May I go for it? Yes. Page, in these writ petition, the petitioners have taken the point that they were not parties to the civil appeals, which were dismissed by the Honorable Supreme Court upholding the judgment of the Division Bench of the High Court. In this petition, the petitioners accepting the fact that a scale of pay 306.85 in terms of ROPA 81 is applicable only for those posts for which minimum qualification is pass in SF examination, minimum recruitment qualification of assessment leading up to class 8 in terms of the verdict of Honorable Supreme Court are not entitled to get the said scale in terms of ROPA rules, and corresponding revised scale of rupees 1040 with effect from so and so in terms of ROPA had taken a new ground by referring to the report of Third Pay Commission in para 12.9 of chapter 2, page part 1, page 85, which reads as follows. Holders of technical posts requiring 2 years state certificate from the Industrial Institute after class 8 pass have been granted lower scale than 300 as they did not have SF pass qualification. Why the question is coming? It is a case not those do not have the qualification, SF qualification. Do you really contradict that we are not SF qualified? No, what it is said that well, these people are below the standard, below SF qualification. If we are admittedly holding the SF qualification in that case, why should we not get the benefit of the rule of 1981? The petitioners have contended that according to the ratio of the decision of the Supreme Court, in the case of Uttar Pradesh, the aforesaid recommendation of the Third Pay Commission to the effect that the time spent for technical training or experience for 2 years after reading up to class 8 is not less than that of SF qualification should not ordinarily be interfered with by the court. Disturbing your lordship, again I am repeating this particular paragraph.
Yes.
The petitioners have contended that according to the ratio of the decision of the Honorable Supreme Court, in the case of Uttar Pradesh, Chaurasia reported in 1991 SCC, the aforesaid recommendation of the Third Pay Commission to the effect that time is spent for technical training or experience for 2 years after reading up to class 8 is not less than that of SF qualification should not ordinarily be interfered with by the court. The contention of the petition is that in the light of the aforesaid recommendation, the minimum qualification required for assistant owner must be construed equivalent to SF pass as 2 years spent for practical experience in the operation, maintenance, so and so, is not less than that of SF qualification. Well, it is just a comparison. That even if 2 years training period is there, that will be equivalent, that 2 years should be counted as an equivalent to SF qualification. But our case is not that even. We assert that we are SF qualified. The petitioners have alleged that this aspect of the matter was neither placed nor considered by the Honorable Supreme Court at the time of passing the aforesaid orders dated 6/9/90 and 7/9/90 in civil appeal number so and so. The judgment of the Honorable Supreme Court was therefore passed sub silentio, and therefore, having regard to this fact and also the fact that petitioners are not parties in the aforesaid civil appeal, the fixation of the petition in the scale of 245, 455 with effect and in the scale of 875 460 with effect is malified, arbitrary and illegal. Further, since the aforesaid orders have civil consequences so far as the petitioner is concerned, this order should be struck down by invoking the principle of ode alteram partem. In all these 4 petitions, the petitioner paid inter alia for the following reliefs. Yes. When my lord, the rule to issue. Recall the order dated 23rd October annexed H and order being annexed J to this petition, rule to issue ad interim order. By order, paragraph 7. By order dated 10/12/90, Honorable Justice S.K. Sen as his lordship then was granted ad interim order in all these 4 writ petitions the following manner. There will be an interim order directing the respondents to maintain status quo with regard to the salary of the petitioner as was paid to them in October 1990, in respect of future salary of the petitioner until further order, on the undertaking of the petitioner that in the event writ petition fail, the excess amounts who paid will be adjusted against the salary of the petitioner that may be payable in future or against the retiring benefit. As the case may be, the petitioner will not raise any objection. The respondents will be at liberty to apply for bill. Now, my lord, I believe, my lord, this particular clause that it will be recovered, my lord, at one stage the Supreme Court revoked that particular. My lord, China? Yes. Everything is revoked in the court. He ordered the Supreme Court to recall current. That is what I am saying. Yes. Yes, my lord. Yes, that is correct. The Supreme Court said it could not be recovered. And on the question of recovery, the Department of Personnel has also issued notification. A notification issued. If I am not at fault, then you cannot recover. You cannot recover. Then, my lord, therefore, the petitioner had found supplementary. Yes. Could we continue, my lord?
We can't go through it today, this entire thing.
Yes, still now, it is quite big one.
You have at least another 20 pages to go.
A masterpiece of order.
Tomorrow we can continue.
Tomorrow is Monday here. Tuesday? Monday or Tuesday, anything, madam?
Monday, Tuesday, we have just fixed too many matters.
Tuesday also? Monday or Tuesday? 2 p.m.
Tuesday we have fixed that matter.
Achhe.
Tuesday that matter we have